Chapter 3. Subrogation in cases of suretyship. 86. Surety's right of subrogation. A. Surety, on paying the debt for his principal, is entitled to be subrogated to all the securities, funds, liens, and equities which the creditor holds against the principal debtor or as a means of enforcing payment from him. This right will be enforced whether the surety is bound in one instrument with the principal or not, and it will be transmitted to the surety's assignees and to his creditors when the principal demand has been so used as to destroy their subordinate liens upon his property, and to his heirs when necessary for their protection, and to his grantees who have lost the property conveyed by him to them in consequence of its being taken upon the principal obligation, and the creditor must do nothing to defeat this right of subrogation on the part of the surety, or to vary the position of the surety. If he takes from the principal debtor a pledge or security for the debt, he must hold the same fairly and impartially, for the benefit of the surety as well as for his own protection. And if he parts with such property without the knowledge and consent of the surety, he will lose his claim against the latter to the extent of the value of the property so surrendered. The surety is discharged, at least pro tanto, whenever by reason of the affirmative act of the creditor, the surety can no longer be substituted to the rights and securities of the creditor. The rule is undoubted, and it is one founded on the plainest principles of natural reason and justice, that the surety paying off a debt shall stand in the place of the creditor, and have all the rights which he has, for the purpose of obtaining his reimbursement. It is hardly possible to put this right of substitution too high, and the right results more from equity than from contract or quasi-contract, unless in so far as the known equity may be supposed to be imported into any transaction, and so to raise a contract by implication. A surety will be entitled to every remedy which the creditor has against the principal debtor, to enforce every security and all means of payment, to stand in the place of the creditor, not only through the medium of contract, but even by means of securities entered into without the knowledge of the surety, having a right to have those securities transferred to him, though there was no stipulation for that, and to avail himself of all those securities against the debtor. But the surety cannot acquire by subrogation any greater rights than the creditor himself enjoyed. 87. It is an equitable assignment to the surety. Although the surety's right of subrogation has been sometimes limited to securities in the hands of the creditor at the inception of the suretyship, yet it is now settled that no such limitation exists. So soon as the surety pays the debt of his principal, there arises in his favor an equity to have all the securities held by the creditor for the demand turned over to him, and to avail himself of them as fully as the creditor could have done. For the purposes of his indemnification, he is entitled to be subrogated to all the rights, remedies, and securities of the creditor, and is allowed to enforce all the creditor's rights and remedies and means of payment against the principal. Although the surety's payment discharges the debt and extinguishes all the securities, so far as it concerns the creditor, it does not have that effect as between the principal and the surety. As to these, it is in the nature of a purchase by the surety from the creditor, and does not exonerate the principal debtor. It operates in equity as an assignment of the debt and the securities to the surety. The right of subrogation and the equitable assignment relate back to the time of entering into the contract of suretyship, as against the principal and those claiming under him. If a question is made whether the acts of the surety have been such as to keep the security on foot, the court, in the absence of evidence to the contrary, will presume that they were done with that intention which is most for the benefit of the party doing them. Thus, the guarantor of a promissory note or other debt will be subrogated to the rights of the creditor to whom he has made payment, and since the surety is entitled to the benefit of all the securities for the debt, all persons taking any of them, either from the principal debtor or from the creditor with notice of the facts and of the surety's responsibilities, are bound in equity to hold them for his benefit. Nor will it make any difference that the surety, in entering upon the obligation, did not rely upon the security or even know of its existence. Any collateral security received by the creditor from the principal debtor will inure to the benefit of the surety. 88. Surety subrogated to priority of creditor. Accordingly, where the government is entitled to priority in the payment of a debt, a surety for the debtor will, upon paying the debt to the government, be subrogated to its priority, and he can enforce this right in a court of equity. This doctrine has been applied to the case of a surety upon a custom house bond for the payment of duties to the United States, even in cases in which there was no statutory provision for such substitution, the owner of the goods not having been a party to the bond. And also in favor of some of the sureties of a United States collector who had made default and died insolvent, after their payment of his indebtedness to the United States, as against their co-sureties, and also to protect such sureties against the principal debtor. But where the principal debtor is still further indebted to the government, the surety, although he has paid all for which he was bound, cannot be subrogated to this right of priority in competition with the government, nor will the surety necessarily be subrogated to all the prerogative rights of the government. And the claim of sureties upon bonds given to the United States for the payment of duties upon imported goods, which they have since paid, is superior to the claim of a purchaser of these goods from the importer, although such purchaser has lost the goods by reason of an unlawful sale of them for the same duties by the collector. 89. Sureties of a trustee subrogated to the rights of the trustee and of the cestui qui trustant. Where the sureties of a trustee have been compelled to answer for his breach of trust, they are subrogated to the remedies of the trustee, and to the rights of both the trustee and the cestui qui trust against those who have participated in his wrongful acts. The guardian of an infant having wrongfully assigned a bond payable to him in his official capacity, and the sureties upon his official bond having made up the loss, they were allowed to recover from the assignee of the bond, just as the ward could have done. The sureties of a deceased guardian who have satisfied the ward for his default will be subrogated to the rights and remedies of the ward against the guardian's estate, and against all parties whose liability was primary to that of the sureties. The sureties upon the official bond of an insolvent clerk of court will in equity be entitled, upon a breach of trust by their principal, to all the remedies and securities that were in the power of the cestuis qui trustant or the creditors against one who participated in the breach of trust. If an administrator, being about to leave the state, deposits the assets of the estate with a stranger, in trust for the next of kin of the intestate, the sureties of the administrator, against whom recoveries have been had by any of the next of kin, have a right to call upon this stranger for an account of the assets so received by him, and to be subrogated against him to the rights of such of the next of kin as have held the sureties to responsibility. And although it has been decided in Massachusetts that a surety upon an administrator's p-bate bond, who has been obliged to pay a judgment recovered by the heirs at law upon the bond, and has taken an assignment of all their rights in the estate and all claims of theirs therefore, cannot maintain a suit against an agent of the administrator having in his hands moneys belonging to the estate. Yet this decision was put upon the ground that the heirs could not themselves have maintained such an action, but were restricted to their remedy upon the administrator's bond. A surety upon an administrator's bond, who has paid 1/2 of a judgment recovered by a creditor of the intestate against the administrator, will not be subrogated to the rights of the creditor whom he has partly paid, but to those of the administrator for whom he has made the payment. For a surety's subrogation to the remedies of the creditor is allowed only when the creditor has been fully satisfied. 90. Sureties of a sheriff subrogated to rights which they have satisfied for him. The sureties of a sheriff who have been compelled to pay a judgment recovered against him by the owner of property, which he had taken on an execution against a third party, and had turned over to the judgment creditor, have been allowed to recover the value of such property against that plaintiff. The sureties who had satisfied the owner were substituted to his cause of action against the creditor. So if the sureties of a sheriff have to pay money for the default of his deputy in failing to take a bail bond from the defendant in a writ, they may in equity be subrogated to the rights of the sheriff against such deputy, and may also resort to a fund which the deputy had obtained from such defendant to indemnify himself against the consequences of the same default. They could also resort to the sureties in a bond given by the deputy to the sheriff to secure the latter against the deputy's delinquencies in office. The sureties of a sheriff who have been compelled, by reason of his default, to pay to the owners of land the amount for which he had sold the land in partition proceedings, will be subrogated to the rights of the sheriff in a note which he took for the price of the land from the purchaser at his sale. The sureties of a sheriff who have been compelled, through his neglect to serve an execution committed to him, to pay the amount of such execution to the creditor therein, will be subrogated to the rights of the creditor against the original defendants in the execution, just as the sheriff would have been if he had himself made the payment. 91. Subrogation of a debtor's surety against a sheriff. Where a plaintiff recovered judgment and issued execution against both principal and surety, and the sheriff collected the amount of the judgment from the principal debtor, but paid over only a part thereof to the plaintiff, and the surety paid the balance of the judgment to the plaintiff. Neither of them then knowing that the sheriff had the funds in his bands, the surety was subrogated to the plaintiff's claim against the sheriff for such funds. A surety, who has been obliged to satisfy an execution against his principal in consequence of the sheriff's having wrongfully applied the proceeds of the principal's property to the payment of a junior execution for which the surety was not liable, will be subrogated to the prior creditor's remedy against the sheriff, as he will be if the opportunity of obtaining satisfaction from the principal has been lost by the fault of the sheriff. But if the liability of the sheriff had been for mere negligence in not collecting and returning the execution, under such circumstances that the sheriff himself, upon making compensation for his default, would have been entitled to be subrogated to the rights of the creditor against all the defendants in the execution, then a payment by the surety would not have entitled him to any redress against the sheriff, unless the sheriff's neglect had resulted in a loss to the surety for which he could not obtain satisfaction from his principal. And the surety cannot be subrogate to the principal debtor's remedies against the sheriff, until the surety shall have satisfied the judgment. In a suit at law on a constable's bond for an escape, if since the bringing of the action the original judgment has been satisfied by a surety for the debtor, no more than nominal damages will be allowed, even though the suit, after this satisfaction, was prosecuted for the benefit of the surety. 92. Surety subrogated to corporations' lien upon the stock of its shareholders. When corporations have a lien upon the stock of their shareholders for the payment of debts due from the latter to the corporations, a surety paying such indebtedness will be subrogated to this lien, and if the corporation abandons this lien, it puts itself in the place of the debtor. The surety's equitable right attaches the instant the lien of the corporation commences, and is consummated by his payment of the indebtedness for which he is bound as surety. If, however, the corporation, though having the power to create such a lien, has never exercised its option to do so, then no lien exists, and there is nothing to which the surety can be subrogated. 93. Surety entitled to be subrogated, though not in privity with his principal. The surety will be subrogated to the rights of the creditor against the principal, though there is no privity of contract between the principal and the surety. A. Owed a debt to B, who was indebted to C, at the request of B, and in pursuance of an arrangement between B and C. A. Gave a bond and mortgage for his debt directly to C. A third party then, at the solicitation of B, but without any request from the mortgagor, guaranteed the payment of the bond, and was compelled to pay it upon his guarantee. And he was subrogated to the benefit of the mortgage for his reimbursement, although he had no remedy at law against the principal debtor. For the surety's right of subrogation does not rest upon contract or privity, but upon principles of natural justice and equity. And it would have been no defense to the surety in an action against him by the creditor that he became surety without the privity of the principal, though he might not have been able to obtain indemnity from his principal by an action at law. So a surety for a part of the debt, as he cannot be subrogated to the creditor's securities until the whole debt is paid, may pay the whole debt, including the part for which he is not liable, and enforce the creditor's securities to reimburse him for his full payment. 94. Surety upon a bond entitled to the benefit of a prior bond for the same debt. Where a bond has been given by two debtors for the payment of a debt, and after the death of one of them, the other gives a new bond with a surety for a part of the demand due upon the first bond, such surety, after paying the amount of the second bond, and taking an assignment of the first bond, may enforce it against the estate of the deceased debtor. The surety will be subrogated under any other bonds held for the same debt. 95. Surety subrogated to the benefit of an agreement made by his creditor. A surety has an equity to be substituted to the benefits obtained by the creditor under an agreement made with other creditors of the same debtor, allowing him to share in the proceeds of property of the debtor upon which B would otherwise have had no claim. If a vendor of land has authorized his vendee to bring suit against an adverse occupant of the premises, agreeing to allow as a part payment of the purchase money the vendee's expenses in prosecuting the suit, sureties on a bond given by the vendee for the prosecution of the suit will, upon being held on their bond, be subrogated to the rights of their principal, the vendee against the vendor under this agreement. 96. Surety of a purchaser subrogated to vendor right of rescission. Where the seller of property has the right to rescind the sale for the non-payment of the price, a surety of the purchaser, upon being compelled to pay the price, will be subrogated to this right. After the sureties have been compelled to pay the debt and have established their claim against their principal, they will be subrogated to all the creditor's rights in equity and may set aside any conveyance which the creditor could have avoided. But the endorser of a note given by the master of a steamboat for stores and supplies furnished to the boat does not, by paying the note, become subrogated to the right of the party furnishing the supplies to have a lien on the boat. The object of the note was to prevent the lien, and the endorser's remedy is on the note itself. He may be subrogated to the rights of the payee of the note, but not to those which were waived by the taking of the note, for he cannot claim by subrogation any greater rights than belong to the original creditor. 97. Surety of a purchaser subrogated to a title or lien retained by the vendor. A surety for the price of property purchased, the title to the property being retained by the vendor as additional security for the payment of the price, has an equity if he is compelled to pay the purchase money or a balance thereof after a partial payment by the purchaser to resort to the property for his reimbursement. The vendor still holding the legal title and having the power to sell the property for the payment of the purchase money, the surety, on being held liable for the purchase money, may be subrogated to this right. And this right will not be destroyed by the purchaser's sale and conveyance of his interest in the property. Whenever the vendor of property, real or personal, retains a lien thereon for the payment of the purchase money, a surety for the purchaser who is held liable for the purchase money is entitled to be subrogated to this lien, except such a lien as is merely personal and unassignable. So, if property is sold under a decree of court, the title being retained or a lien reserved upon the property for the purchase money, the purchaser's surety for the price may be substituted to this lien upon the default of the purchaser, and may have the property sold for his relief, even before he has himself paid the price, and although the principal debtor has himself transferred his interest in the property to other persons. Though the surety cannot ordinarily be subrogated to the rights of the creditor against the principal debtor until he has actually paid the debt, yet under such circumstances the surety has been allowed to have the property resold for his own protection, because the surety's right to hold for his indemnity the property thus purchased is superior to that of the purchaser, the principal debtor. 98. Surety for vendor subrogated to equitable rights of vendee. A. Surety for the vendor to the vendee of property will, upon answering for the default of his principal, be subrogated in like manner to the equitable rights of the vendee against the vendor. Thus, where the vendor of land gave a bond with surety to the vendee, conditioned to make a title to the land upon payment of the purchase money, and before the money was all paid the land was sold on an execution against the vendor, who became insolvent, and thereupon the vendee sued the surety upon the bond, and recovered judgment against him for the money that had been paid, it was held that the surety could follow the land, and have remuneration out of it in the hands of the purchasers at the sheriff's sale for the amount that he had thus been compelled to pay, being subrogated to the purchaser's equitable lien upon the land for the reimbursement of partial payments of the price. 99. Right of vendor who becomes surety for vendee. A vendor of land took the purchaser's note for the price thereof, and gave a bond for title when the purchase money should be paid. When half the purchase money had been paid, the vendee sold the land, giving a warranty deed thereof to a bona fide purchaser for value, who had no knowledge that the title was still in the original vendor. Afterwards, the vendor knowing of this conveyance, the original vendor and vendee made a verbal agreement that the vendee should pay the balance of his purchase money by paying a debt of the vendor, giving his own note therefore with the vendor as a surety, and that, if the vendor as such surety should be compelled to pay this note, the purchase money should again become due from the vendee to the vendor, and the vendor should still hold the legal title to the land as security therefor. The vendor was compelled to pay this note, and then evicted the new purchaser from the land and held it himself under his legal title. The vendor then claimed the balance of the purchase money from the vendee, and the vendee's purchaser claimed damages for the breach of the vendee's warranty. It was held that the original price was paid by the making of the verbal agreement between the vendor and the vendee, and that the indebtedness for this price was not revived by reason of the contract of suretyship, but that the original vendor, having elected to rescind his contract of sale by resorting to his legal title and evicting his vendee's purchaser, and having thus made his vendee liable in damages to such purchaser, he must refund to his vendee the half of the purchase money which he had received. 100. Surety entitled to funds held for the debt in the hands of his principal. Where sureties are held to pay the debt of their principal, they are entitled in equity to the benefit of all funds and assets, so far as these can be specifically reached, which their principal held as specifically applicable to the debt which they have paid, and to have these funds and assets made available for their protection. A person taking any of such securities from the principal debtor, with notice of his responsibilities, is bound in equity to hold them for the indemnification of the sureties. So the surety may enforce the principal's right to indemnity or repayment from others. Where one who held a mortgage as administrator took a deed of the equity of redemption from the mortgagor to himself individually, it was held, since this deed only made absolute the defensible estate already vested in him as administrator, that an agreement by the legatees of the estate that he should hold the land in his own right, leaving his sureties liable for the balance due upon his account, could not be supported against the sureties, but that the latter could resort for their indemnity to the land, both in the hands of the administrator and of his grantee. Where one became surety upon the principal debtor's promise that certain stock should be pledged for the payment of the debt, but the principal died before the transfer could be made, the execution of this agreement was enforced against his executor, although his estate was insolvent. Executors who have paid a debt for which their testator was liable merely as a surety for a residuary legatee will have a lien upon the legacy for their reimbursement superior to that of a mortgagee of the legacy. Where the note of one who had died indebted to a bank was renewed by his executor, as such with a surety, the surety, having paid the note, was substituted to the claim of the executor as well as of the bank against the assets of the estate, and the executor being in advance to the estate by reason of the note which the surety had paid, the amount thus due from the estate to the executor was ordered to be paid to the surety in preference to a subsequent assignee from the executor. But in Alabama, under similar circumstances, it was held that as the claim of the creditor against the estate of the deceased principal was barred by the taking of the new note, and only the parties to the new note were liable upon it in their individual capacity, the surety upon the new note, when he was compelled to pay it, had no equity against the estate of the deceased principal note, the executor having no power to bind his testator's estate by a new contract. 101. Surety may avail himself of his principal's right of set-off or defense. A surety, when sued upon his contract, may avail himself of his principal's right of set-off growing out of the same transaction. Thus, it is a good equitable defense to the surety as to part of the amount claimed of him, that a dispute as to the consideration of the contract having arisen between the plaintiff and the defendant's principal, and the dispute having been referred to arbitration in accordance with the original agreement, this amount had been awarded to the defendant's principal, which the principal had offered before suit brought to set off against the present claim. So, when the payee of a note sued a surety thereon, and it appeared that the note was given for a tract of land sold by the payee of the note to the principal maker, and that at the time of the sale there was an encumbrance upon the land, which the principal had since discharged with the consent of the plaintiff, and upon the latter's promise to allow it as a credit upon the note, it was held that this promise to the principal inured also to the benefit of the surety, and operated a satisfaction of the note pro tanto. The surety may in general set up against the claim of the creditor any legal or equitable defense which would have been open to the principal, such as the estoppel of a previous judgment between the creditor and the principal. But the surety's equity to avail himself of his principal's right of set-off against the creditor does not extend to distinct demands of the principal, not in themselves available by way of set-off, and not growing out of the same transaction, unless the principal is insolvent or the principal has taken advantage of the set-off in a joint action against principal and surety. And this right of set-off is reciprocal to the creditor and the sureties as against the principal. But the surety cannot, without the authority of the principal, set up against the creditor the failure of the title to the property for the price of which he became surety. The principal may bind his surety as well as himself by waiving the defense of a defective title or a breach of warranty in the conveyance by which the debt was created. The surety is bound in the same manner and to the same extent as his principal, and if the latter is satisfied with his purchase, it cannot be rescinded by the surety for a defect in the title which is given, and the surety may prosecute an appeal or a writ of error to reverse a judgment recovered against the principal which would have been conclusive upon the surety. 102. The surety is a creditor of the principal. When the principal debtor is bankrupt, the sureties, in respect of their liability, are regarded in equity as his creditors, and may retain any funds of the principal in their hands, even against a bona fide purchaser thereof for value without notice of their rights. The surety is regarded in equity as a creditor of his principal, and has all the privileges of a creditor from the time of his signing the obligation by which he is bound, just as he is liable to the creditor from that time. Though his right of action against his principal and his equity to be subrogated to the securities held by the creditor do not become complete until his payment of the debt. Though the principal's liability to indemnify his surety is, previous to payment by the latter, merely contingent, it is nevertheless a debt, and will be embraced within the terms of a will made by the principal charging his real estate with the payment of his debts. But when a surety is liable as such for several different debts of the same principal, the latter may assign a debt due to him from the surety for the security of any one of these debts that he may choose, and if the surety is privy to a deed of trust which assigns a demand due from him to his principal, the assignor, and the deed being otherwise to his advantage, makes no objection at the time to the assignment, he is taken to have waived for a compensation any zoninity he may have had against his debt, being thus included in the trust fund so assigned. 103. Surety does not lose this right by agreeing to exonerate his co-sureties. One of the sureties upon the note of a corporation, which was signed by several sureties, and was also secured to the creditor by a mortgage upon the property of the corporation, does not cease to be a surety or lose his right of subrogation as against the corporation by agreeing for value with his co-sureties that he will himself pay such note, and upon its payment by him, he will be subrogated to the rights of the mortgagee as fully as if no such agreement had been made, and may enforce the mortgage, both against the corporation and also against other creditors of the corporation holding liens junior to the mortgage. No private arrangement among the co-sureties, for the distribution of the burden of their joint liability among themselves, will affect their rights against their principal. 104. One who has pledged his property for the debt of another entitled to subrogation. One who secures the payment of another's debt by a charge or mortgage upon his own property is a surety, and is, upon his payment of the debt, entitled like any other surety to be subrogated to the benefit of the securities held by the creditor from the principal debtor. Nor will this right be affected by the fact that the charge upon the property of the surety was created by the same instrument by which the property of the principal was mortgaged to the creditor, and that this instrument provided that, upon payment by either principal or surety, the creditor should reconvey both the charge of the surety and the mortgaged lands of the principal to be held upon the same uses as before the execution of the instrument. If a wife becomes a surety for her husband by the creation of a valid lien upon her own estate for the payment of his debt, she will be entitled to the same equitable rights as would be enjoyed by any other surety, and will be subrogated to the rights of the creditor against her husband's property, even against her husband's assignee in insolvency, and even though the property has come to the hands of a bona fide purchaser from her husband, if such purchaser, but for his own negligence, would have been aware of her rights. And the creditor's lien upon the property of such a surety will be discharged by any interference on his part with her right of subrogation. As against her husband, she is entitled in equity to have his property first applied to the payment of the debt, and this right will pass to her grantees and to her creditors and heirs. 105. Extent to which subrogation will be carried. The subrogation of a surety will not be carried further than is necessary for his indemnity. If he buys up the security at a discount or makes his payment in a depreciated currency, he can enforce it only for what it cost him. He cannot speculate at the expense of his principal. His only right is to be repaid. Nor will he be subrogated for payments which, when made, were made as gifts to the principal. The extent to which the remedy will be carried for the surety's indemnity will be governed by equitable considerations. A surety who had been subrogated to the rights of a landowner to whom he had been compelled to pay the debt of his principal for land which his principal, a railroad company, had taken under the right of eminent domain, was not allowed to stop the running of trains over the land, as the creditor might have done, until he was repaid, because the court saw that this could be of no benefit to him, the company being insolvent and in the hands of a receiver, and the road being operated by a trustee merely for the accommodation of the public, and with a view to a more advantageous sale on foreclosure. For equity will not do that which would be of no benefit to the party asking it, but merely a hardship to the parties sought to be coerced. A surety in a bond given in admiralty proceedings who has been compelled to pay the amount of a decree will be subrogated to the rights of the libelant against his principal, but not to the maritime lien which was destroyed by the bond. And a surety who has paid the joint note of his principal and himself cannot reissue it, so as to bind any one but himself, without the consent of his principal. 106. Surety of surety may be subrogated. How far? A surety of a surety, who has paid and discharged the principal obligation, has the same equity of subrogation to the securities and remedies of the creditor as belonged to the surety for whom he was bound. But he can have no greater rights than his immediate principal would have had. A joint judgment having been recovered against several, one of them, who was originally only a surety, was taken on the execution, and gave a bond with a new surety to obtain his release. And it was held that this new surety, having been compelled to pay the debt, was entitled to be subrogated to the creditor's remedies against the land of the original principal, although this land had been sold by the principal, and bad come into the bands of a bona fide purchaser for value without notice of the circumstances, before the service of the execution upon the original surety. But the surety of a surety who has been compelled to pay the creditor cannot be subrogated to the place of the creditor for the purpose of enforcing payment from the principal, if the latter has already paid his immediate surety. The immediate surety can recover of the principal where the debt has been paid by his own surety, treating the payment as made by himself through the latter as his agent, where the latter holds the immediate surety for his reimbursement. One who has agreed to indemnify a surety from loss will, upon carrying out his agreement, be subrogated against the principal debtor as the original surety would have been. 107. Now far crediting of the surety may be subrogated, where the lands of a surety have been taken for the debt of the principal, though the subsequent judgment creditor of the surety, who have thus lost the benefit of their lien upon his lands, have an equity to be subrogated to the lien of the judgment against the principal to the extent to which they have been deprived of the proceeds of the surety's lands by reason of the prior judgment against principal and surety. Yet this equity depends entirely upon the rights of the surety against the principal, and is limited to the balance of general accounts between the principal and the surety. And if the surety was in form and apparently a mere joint debtor, his creditors cannot by subrogation claim his rights as a surety so as to prejudice junior liens against the principal debtor. The claim of a creditor of the surety, such creditor having been deprived of the opportunity to secure the payment of his demand by the surety's property having been taken to pay the principal's debt, will be preferred to that of an assignee of the surety whose assignment was made after the right of the creditor had accrued. 108. Creditor cannot discharge security for his own benefit after payment by surety. An endorser of a note which is also secured by a mortgage is entitled to look to the proceeds of the mortgaged premises for his relief, and if in such a case the creditor, after receiving payment from the surety, cancels the mortgage without the surety's consent, so as to leave the land subject to a junior lien for another debt, which the creditor holds against the principal debtor, the claim of the surety to have reimbursement out of the land will have priority over the creditor's junior lien. The surety's right of subrogation is superior to the creditor's claim to hold the security for another debt, not covered by the agreement, and one who, as surety for the second endorser of a negotiable note, has been compelled to pay the note, is entitled to a recourse against the first endorser to recover the amount which he has thus paid. 109. Instances of the application of the doctrine of subrogation for the protection of sureties. Several parties having united in the purchase of land and given their joint bonds for each one's share of the purchase money to one of their number, in whom the legal title to the land was tested as their trustee, and one of them having failed to pay his share of the purchase money, the sureties on his bond, who were his associates in the original purchase, paid it for him. And thereupon it was held that they acquired an equitable title to his share in the land, and that, until they were fully reimbursed for their payment of his share of the purchase money, neither he nor those claiming under him could demand of the trustee a conveyance of his share or a declaration of trust in his favor. A trustee appointed by a court of chancery to sell certain land sold the same, and took the purchaser's bond with a surety for the payment of the purchase money, the land not to be conveyed until the purchase money was paid. This purchaser soon after sold the land for the same sum that he had agreed to pay to the trustee for it, to a sub-purchaser, who, knowing that the trustee had not been satisfied, paid to his own grantor the whole price of the land, and received from the latter an assignment of a claim of his against the owner of the land, which it was thought would be more than sufficient to pay for the land. But the estate turned out to be insolvent, and the dividend upon this claim was not sufficient to pay the purchase money to the trustee, who accordingly withheld the conveyance from the sub-purchaser, to whom he was ordered by the court to convey the property upon the purchase money being paid, and sued the surety on the bond of the original purchaser, and recovered a judgment for the unpaid portion of the purchase money. The surety then claimed that what he was thus compelled to pay should be charged for his reimbursement upon the land in the hands of the sub-purchaser, and it was held that unless this sub-purchaser should pay to the surety the amount of his payment, the land or so much of it as might be necessary should be sold to raise that amount. For the sub-purchaser could not by his purchase put the surety for the original purchase money in a worse position than the latter would otherwise have occupied. A tract of land was sold 3 times by the successive purchasers thereof, the original vendor retaining the title and reserving a lien on the land, as well as taking a bond with sureties for the payment of the purchase money. Under these circumstances, one of these sureties advised a party to buy the land, but gave him no intimation as to the lien. The court held that, although this advice and concealment might stop that surety from asserting any equity for his own benefit, to the prejudice of the party who purchased it upon his advice, it could not affect the rights of the first vendor, and the purchase money having remained unpaid upon each successive sale, that the land might be sold under the first lien, to which the sureties, who had paid the debt secured thereby, were subrogated. But where the vendor had given a full title to the land sold, taking the vendee's bond with 2 sureties for the payment of the purchase money, it was held, upon the insolvency and death of the vendee and one of the sureties, and after a sale of the land by a divisee of the vendee to a purchaser with notice of the circumstances, that there was no lien upon which the other surety could hold the land for his indemnification upon the bond. 110. Surety's right of subrogation may be lost by his waiver. The right of a surety to be subrogated to the benefit of the securities and remedies held by the creditor against the principal debtor may be lost by the surety's waiver. If one who claims to be a surety has for a long time allowed himself to be held out as the principal debtor, and other rights have in the meantime accrued against the real principal, it is then too late for him to claim to be subrogated as a surety to the prejudice of those rights. A year's delay in a similar case has been fatal to the rights of the surety, other liens having in the meantime attached upon the estate which the surety desired to hold, and the delay having been made with knowledge of the facts. Where a bill in equity quia timit was filed for subrogation against persons who might be ultimately liable, the ground of action being for bonds when more than 20 years before the suit was brought, it was held that the complainants had lost their right to relief in equity by their lashes in negligently lying by until, by reason of the lapse of time, there could be no safe determination of the matters in controversy. And just as the surety could not recover from his principal upon his voluntary payment of a debt barred by the statute of limitations, so he will be taken to have waived his privilege of subrogation, unless he claims it before his remedy at law against his principal is barred by lapse of time. the right of subrogation will be barred by the statutory period of limitation like any other right. But the mere lapse of a shorter time is not of itself a bar to the right, though the surety's bare delay, if protracted, is evidence against him of a waiver of his right. The surety's right of subrogation accrues upon his payment, and as to his principal, the statute then begins to run against him, and he should then call at once for the securities if he desires to be subrogated to them. The surety has an election to seek his reimbursement, either by subrogation to the remedies of the creditor, or by an action against his principal upon the latter's implied promise of indemnity. His failure, upon paying a debt secured by mortgage from the principal debtor, to take either a discharge or an assignment thereof has been held to bar his right to a decree for foreclosure of the mortgage by right of subrogation. Indemnity received by the surety from a stranger will be regarded as cumulative to the rights which the surety already possesses. One who is manifestly a surety will not be deprived of the benefit of subrogation to a mortgage security held by the creditor, merely because he took other security from the principal, which he afterwards released, and did not ask for an assignment of the mortgage immediately upon his payment of the debt which it secured. But he cannot disregard the rights of other parties which have accrued in the meantime. Thus, if the vendor of land has a lien thereon for the price, a surety of the vendee who pays the price will not be subrogated to this lien, if he has taken other security from the vendee for his protection, and has without objection allowed the vendee to sell the land to another purchaser, although this security afterwards turns out to be insufficient. The election of the surety to claim greater rights under an express agreement than he would acquire by subrogation is a waiver of his right to subrogation. If he refuses to accept the security when offered to him by the creditor, he waives his right to demand it afterwards. And if, after a surety for two principals has paid the debt, he takes from one of the principals a security for his reimbursement, he has been held to waive his right to the benefit of a security which had previously been given by the other principal to the creditor. If he has the means of reimbursement in his own hands and refuses or neglects to make due application thereof, he cannot come upon another fund by way of subrogation. But a surety who has unsuccessfully attacked for alleged fraud an assignment made by his principal, the benefits of which have been accepted by the creditor, is not thereby stopped from asserting his right of subrogation to the creditor as to these benefits. Nor is it necessary to the surety's subrogation that his payment should have been coerced by an execution. His payment, though voluntarily made, will be regarded as compulsory whenever it could have been enforced. 111. Surety's right of subrogation subject to creditor's rights. It has been held that the surety's right of subrogation to the securities held by the creditor cannot be enforced to the prejudice of an intervening charge taken by the creditor from the principal debtor in ignorance of the suretyship. Thus, where A and B had given to a creditor their joint and several note, secured by a mortgage of their respective estates, and then A gave a separate mortgage of his own estate to a creditor of his own, who afterwards took an assignment of the prior mortgage, and it then appeared that B had joined in the first note and mortgage merely as the surety of A and B, claimed that upon paying the first debt he was entitled to be subrogated to the rights of the mortgagee and to hold the entire mortgaged premises for his indemnity. It was held that, before B could claim the rights of a surety against A's creditor, he must show that the latter knew or had the means of knowing of the suretyship, and the court said that though a creditor cannot tack to an existing mortgage debt a demand not secured by the mortgage, nor a subsequent mortgage to a prior one as against an intervening encumbrancer, yet a mortgagee may take another mortgage, which will be valid against an intervening encumbrance implied by equity, of which the mortgagee had neither actual nor constructive notice. But if the creditor had known that B was merely a surety, though it did not appear upon the face of the papers, that would have been sufficient. Nor will a surety's subrogation to the rights and liens of the creditor be allowed to defeat an interest acquired and held by a third person, when that interest, though subordinate to the creditor's lien, is prior in date to the surety's undertaking. Thus, when a debtor sells property which he had mortgaged for a debt, and then a judgment for the debt having been obtained against him, gives a surety for the judgment, who is afterwards compelled to pay it, this surety cannot be subrogated to the mortgage so as to defeat the purchaser's title, which accrued before the contract of suretyship was entered into. for the subrogation of the surety to the creditor's means of payment rests solely upon principles of justice and equity. But the surety's subrogation will overreach all rights that have accrued since the contract of suretyship was entered into. 112. Surety indebted to his principal not entitled to subrogation against him. The equitable right of subrogation will not be allowed to a surety who is himself indebted to his principal, against whom he asks to be subrogated, without his first satisfying such debt. A judgment against principal and surety having been satisfied out of a sale of the surety's lands, the surplus proceeds in court were claimed by the principal debtor, who held the next judgment lien on the surety's lands, and by subsequent judgment creditor and of the surety, who claimed, by virtue of the surety's payment, to be subrogated to the lien of the first judgment creditor. The surety being also indebted on another account to the principal, and being insolvent, it was held that the payment made out of the surety's estate could not be set off against the principal's judgment, and that the principal had accordingly the first right to the surplus proceeds. And if, as between principal and surety, the payment of the debt has been assumed by the original surety, the latter cannot in equity insist that the property of the former principal is primarily liable for the debt, any more than he could recover against his principal at law after paying the debt. Nor will he have any right of subrogation against his principal upon paying the debt. He has become the real debtor, and so cannot be subrogated. But the surety's right of subrogation will not be destroyed by the fact that the principal has himself become a surety upon another obligation upon which the surety has raised the money to pay the original debt. 113. Surety's right confined to the contract for which he was surety. As the surety's liability is limited to the express terms of his contract, so his right of subrogation is confined to the rights and securities of the contract for which he was surety. One who has guaranteed the payment of a promissory note by an endorser thereof will, upon paying the same, have no greater rights against the maker than the endorser himself had. The bail of a defendant cannot look for reimbursement to one who is jointly liable for the original debt. The surety upon a note will not by paying it acquire any rights against the parties to a former note which had been paid by the note upon which he was surety. If one partner, though for the benefit of the partnership, executes a bond with a surety, this surety, on being compelled to pay the bond, acquires thereby no right of action against the other partners. One who is surety both for a firm and for an individual member of the firm has no right to apply upon the individual debt funds of the firm which may come into his hands. But if, having done so, he afterwards applies his own money to the payment of the firm debt, his rights will be the same as if he had paid the latter debt out of the partnership funds. If one who has bound himself as bail for the defendant, in an action against a shipmaster for the value of property lost through the neglect of the officers and crew, is compelled to pay the amount of the judgment against the master, though he will be subrogated to the benefit of the judgment so obtained, and will have the right of recourse against the owners of the ship, which the master would have acquired by payment of the judgment, yet he will not be subrogated to the original cause of action against both the master and the owners of the ship. Where the accommodation acceptors of two bills of exchange received a deed of trust as security from the drawer, and one of these bills was taken up by giving a new note with a new surety, the surety upon this new note, after paying it, was not allowed to share in the benefit of the original security. If the note of a principal with 3 sureties is discharged at maturity by giving another note with only 2 of the sureties, the third surety having died before the first note fell due, the estate of the latter will not be liable to contribute upon the insolvency of the principal and the payment of the new note by the sureties thereon, although when they executed the new note they supposed that the estate of the third surety would be liable thereon. If 2 executors have given a joint and several bond for their faithful administration, and after the death of one of them the survivor has wasted the estate, the sureties, after satisfying a judgment recovered upon the bond against the survivor and themselves for such waste, will have no right of action against the estate of the deceased executor, either for indemnity or contribution, though if this executor had lived their rights upon the bond would have been complete against him. 114. Surety's right to marshal securities given to the same creditor for separate debts. Where a debtor gives to his creditor collateral securities for the payment of the debt, and afterwards borrows of the same creditor a further sum of money, for the payment of which he gives a surety. The surety, if called upon to pay the second debt, is entitled to the surplus of the securities over the amount needed to satisfy the first debt. The surety for only one loan, if he has been obliged to pay that loan, has a right, against the principal debtor or his representatives, to marshal the securities given by the principal to the creditor for several successive loans, so as to obtain reimbursement for himself out of the balance of the several securities after the creditor is satisfied. The purchaser of several lots of land, having given his separate note for each lot with the same endorser, and the lots having been afterwards resold for his default in the payment of these notes, and some of the lots having brought more and some less than the first contract price, this endorser was allowed to marshal the proceeds of these sales, so as to make good the deficiency of one set by the surplus of the other. So where husband and wife have given security for the husband's debt upon the property of each, she may require the creditor to sell her husband's property before resorting to hers. 115. Surety cannot require the creditor to resort first to security. The right of the surety does not extend to requiring the creditor to exhaust the security given to him by the principal debtor for the payment of the debt before coming upon the surety. The subrogation of the surety will never be allowed to the prejudice of the creditor's right to collect his debt. The latter may proceed against the surety personally, and at the same time subject the collateral security to the payment of his debt until he has obtained full satisfaction. The creditor may proceed against the surety in the first instance, or against the principal and the surety jointly, for the satisfaction of his demand. The payee of a note may maintain an action thereon without first exhausting a mortgage security given by the principal. A guarantor will not be released by the mere fact that the creditor has entered upon the land of the principal debtor under a mortgage given to him by the latter to secure the debt. The existence of a judgment which is a lien upon the lands of the principal, and on which the money might be made by issuing an execution, is no reason for refusing the creditor a recovery against the surety. An endorser of a promissory note given as collateral security for the payment of a sum of money directed by the order of a court of chancery to be paid by the maker of the note on pain of attachment has no right to require the creditor to enforce the attachment previous to calling on him for payment. The surety must first pay the debt, and can then himself enforce the securities. One who in giving a lease of land takes notes with a surety for the payment of the rent, and also reserves in his lease the right of distress, is not bound to resort to the right of distress, but may collect the notes from the surety. Indeed, the right of distress has been held to be the mere personal privilege of the landlord, and not to pass by subrogation to the surety. 116. Right of subrogation destroyed by application of the security upon the debt. Although the surety is entitled to the benefit of a security held by the creditor for the payment of the debt, yet if the whole security has been applied upon the debt without paying it in full, and the surety has been compelled to make up the deficiency, he cannot then resort to the security for subrogation or contribution. For this would so far defeat the very object, the payment of the debt, for which the security was taken. And if the debt is paid by the principal debtor, a mortgage held by the creditor to secure its payment is thereby extinguished, and an assignment of it by the surety to secure money borrowed by him on his individual account is invalid, especially if the lender knew before such assignment that the original debt had been paid. 117. Creditor's right to apply security as needed for his own protection. A creditor who holds against the same debtor several securities for different debts, on which there are distinct sureties, may obtain security or satisfaction, by attachment and judgment or otherwise, of one debt in full, and yet retain his entire claim upon the surety for the others. Neither law nor equity requires that such a payment shall be considered to have been made for the benefit of all the sureties rateably. The holder of one security for different demands may apply the security upon whichever debt he chooses, and still hold a surety upon the others. And where a debtor gave to one creditor a mortgage of two funds, and also a covenant by a surety, and then gave a second mortgage of one of the funds to another creditor, and the second creditor's fund having been exhausted by part payment of the first creditor's debt, the surety paid the balance due to the first creditor, and took a transfer of the first mortgage. It was held that the second creditor had a right to marshal the securities against the surety, and that the second creditor's right to be subrogated to the first fund was superior to the surety's equity. Where the creditor, holding a surety for the payment of his debt, took from the debtor a mortgage to secure both this and an additional indebtedness, it was held that the surety would have no right of subrogation to this mortgage until both debts had been paid to the creditor, and the creditor was allowed to apply all the proceeds of the security upon the second indebtedness, and still to hold the surety for the first. A surety upon an appeal bond, whose liability has become fixed, cannot require the creditor to apply towards the satisfaction of the bond, a party's payment obtained from the property of the principal defendant, but is responsible for the unsatisfied damages arising on the appeal to the full amount of the bond. If a mortgage runs jointly to the creditor and the surety, and is conditioned for the payment both of a note given by the mortgagor to the creditor and of another note given by the mortgagor and the surety to the creditor, the surety cannot, upon paying the note for which he is liable, assert any rights under this mortgage against the creditor until the creditor's other note is paid. If the surety wishes to avail himself of the mortgage, he must, on default of the debtor, pay the latter note also. But if several debts are secured by a mortgage given by the principal debtor, and for some of the debts there are sureties who are not parties to the mortgagee is sometimes regarded as a trustee of the sureties for the security thus provided for their indemnity, and bound to apply a just proportion of its proceeds upon the debts for which the sureties are liable, operating a payment of these debts pro tanto, and discharging the sureties to that extent. If property is deposited with the creditor by the principal debtor, to be applied upon an indebtedness on which there is a surety, the creditor has no right against the surety to apply this upon another debt on which the principal alone is liable, and the proper application, once made, cannot be afterwards changed, so as to revive the obligation of the surety. 118. Surety for part of a debt cannot be subrogated, while the other part remains unpaid. A surety for part of the debt is not entitled to the benefit of a security given by the debtor to the creditor at a different time for another part of the debt. A vendor of land took the notes of the vendee without any other security for the payment of the purchase money, retaining only a lien upon the land to secure the payment of the notes. Regarding the land as an insufficient security, he brought an action upon the first one of these notes, an attached property of the vendee of the value of $1,000. To secure the release of this property, the vendee gave to the vendor a bond with sureties in the sum of $1,000 as security to that amount for the note upon which the suit was brought. Judgment was then rendered for the amount due upon the note. Afterwards the vendor obtained a judgment upon the third note, and sold the land upon these judgments. He applied the proceeds of this sale first upon the last judgment, and only the balance of these proceeds upon the first judgment, leaving due thereon an amount exceeding the bond. The sureties upon the bond contended that, as the first judgment was a lien upon the land sold, they had a right to be substituted as to this lien to the place of the judgment creditor, and that as he had discharged this lien by selling the land on the executions, he had thereby discharged their liability. But it was held that they had no such right, that the doctrine of subrogation did not apply to the case, that it was not the case of a surety asking to be substituted to the place of a creditor who had collateral security for the debt, but of a surety for one part of the debt asking to be substituted for the creditor in relation to a security which the creditor had the right to apply upon another part of his debt, when the effect would be to deprive the creditor of his resources and cause him a partial loss of his demand. But this rule means only that the surety's creditor must be satisfied. If a mortgage is made to two different mortgagees to secure their respective demands against the same debtor, a surety to one of the mortgagees for his demand who pays the same, being the whole amount due to this creditor, will be subrogated to the same pro rata interest in the mortgage, which was possessed by the creditor whom he has paid. 119. Surety discharged by creditor giving up security to which he would be subrogated. As the surety has an interest in every security which the creditor holds against the principal debtor, whether the surety has known of its existence or not, so if the creditor interferes with the surety's right of subrogation by parting with any such security without the consent of the surety is thereby discharged to the extent of the value of such security. Not only an actual parting with a security, but any dealing with it such that the surety cannot have the benefit of it in the same condition in which it existed in the creditor's hands will have this effect. The surety is entitled to the benefit of all the securities in the hands of the creditor, and if any of these are lost by the creditor's acts or neglect, the surety is discharged to the extent to which the acts of the creditor may have prejudiced his recourse for the reimbursement of what he may be obliged to pay under his contract of suretyship, but only to this extent. The surety will not be discharged by what cannot injure him. Accordingly, the creditor will not discharge the surety by making an exchange of securities with the principal debtor, whereby he obtains a more valuable security than he gives up. Any affirmative act of the creditor by which a security of which the surety might have availed himself is put out of the latter's reach operates as a discharge of the surety pro tanto, but only pro tanto. And this principle is now generally extended to securities taken by the creditor after the contract of suretyship has been made, although it has been determined in England contrary to the usual doctrine that the creditor is not bound to retain for the protection of the surety securities for the debt which he may have acquired from the principal debtor subsequently to the contract of suretyship, and which, while the creditor holds them, the surety does not call upon him to enforce, and that a creditor who, having taken a further security from the principal after the contract of suretyship was made, afterwards parts with that security, does not thereby discharge the surety, either wholly or pro tanto. 120. Creditor held to responsibilities of trustee for surety. The creditor who, holding the engagement of a surety, takes also from the principal debtor collateral security for the payment of the debt, is bound to hold the property which he so takes in trust, not only for his own benefit, but also for the protection of the surety. He must act with good faith towards the surety as his cestui quid trust, and hold the fund fairly and impartially for the benefit of the surety as well as of himself. He must account to the surety for the value of the property, not only if he parts with it, or surrenders it without the consent of the surety, or does any affirmative act in violation of the trust upon which he holds it, but also for his negligence or omission to perform any act whereby the surety's recourse to the fund is prejudiced. Though mere non-action by the creditor will not ordinarily release the surety, yet if it is such non-action as to render unproductive some collateral security, such as a mortgage held for the payment of the debt, this will be an available defense for the surety, at least pro tanto. If he waives his security by proving his claim as an unsecured one against the estate of the principal debtor in bankruptcy, this will discharge the surety to the extent of the value of the security thus released, though it has been held that the creditor is none the less entitled to exercise his option of surrendering the security and proving in full against the principal's estate because he holds a surety, and that the surety will not be discharged by such proof. The right of the creditor against the surety will be destroyed by making such a compromise with the principal debtor that the surety cannot for his reimbursement be subrogated to the creditor's rights. But a compromise which preserves the privileges of the surety will not have this effect. 121. Lashes of creditor resulting in loss of security may discharge surety. Accordingly, it has been held that the creditor's failure to record a mortgage or conveyance of property which has been given to him by the principal debtor as a security for the debt, whereby the benefit of the security is lost both to the creditor and the surety, will discharge the surety to the extent of the value of the property. For the loss must be borne by the person to whose neglect it was due. This has, however, been sometimes denied on the ground that the creditor's liability is for positive acts only, not for mere passive negligence. But it is generally considered that the creditor should be held responsible for the loss of any security arising from his wrongful acts, whether of omission or of commission. If, however, the creditor's neglect has not resulted in the loss of any means of payment to which the surety, on discharging the debt, would have the right to be subrogated, the creditor's claim upon him will not be affected, and as lashes cannot be imputed to the government, the failure of a county court to take a mortgage on unencumbered real estate, as was required by statute to secure the payment of school money loaned, will not discharge a surety for the loan. And though a roll of court requires that a recognizance should be taken and recorded for the payment of the rent of property in charge of the court, a failure of the clerk of the court to record such a recognizance, whereby a lien for the rent upon the property of the lessee is lost, will not discharge a surety for the payment of the rent from his liability. So, where an order of court, made in pursuance of a statute, provided that a mortgage should be taken for the purchase money of property sold at an administrator's sale, a surety for the purchase money was not released by the fact that, contrary to his expectation, no such mortgage was taken, no misrepresentation having been made to him. But the creditor is not required to do more for the protection of the surety than to preserve the force and validity of the security furnished by the debtor. It is enough if he is able to produce the security in as good condition as he received it. 122. Creditor discharge of levy or attachment on the property of the principal. How far a discharge of tile surety? If the creditor releases the levy of an execution for the debt upon property of the principal sufficient to satisfy the debt, this will discharge the surety. For this is a security which the surety can require the creditor to preserve. Much less can the creditor, to the injury of the surety, discharge the levy, so as to let in another debt due to himself, or by assigning his judgment to another person, enable the latter, by discharging the levy, to save another debt out of the property, to the loss of the surety. A release of property upon which the judgment is a lien will have the same effect as if the property had been actually levied upon. If the hen of the judgment upon the land of the principal debtor has been lost by the creditors having proved it as an unsecured debt against the estate of the principal in bankruptcy, this will discharge the surety to the extent of the injury thereby resulting to him, but only to this extent. And it has been held that after a levy upon property of the principal, a delivery of such property by the sheriff to the principal debtor will discharge the surety to the extent of the value of this property. For if the creditor was not in fault, the sheriff will be liable to him, and the surety should be released. If the creditor was in fault, then a fortiori the surety should be released, though the doctrine is not commonly carried to this extent. But the mere failure of the officer through negligence to make the money out of the property of the principal will not discharge the surety. If the delay or dismissal of the levy does not annul the lien of the judgment upon the property, then, as the rights of the surety are not thereby affected, he will not be discharged from high liability. A mere suspension of execution will not discharge the surety, unless it is the result of an agreement of the creditor with the principal debtor not to issue execution or not to attempt collection from him. Some act of interference with the surety's right of subrogation to a security or a remedy must be shown to operate his discharge by reason of the creditor's neglect in pursuing the principal or his property. The lien of an attachment for the debt obtained by the creditor upon the property of the principal debtor is a security for the debt which will inure to the benefit of the surety, and its discharge will release the surety, at least pro tanto. Some courts have indeed held that the release by the creditor of an attachment upon the property of the principal will not discharge a surety for the debt, because the creditor is not bound to prosecute a suit or to use any active diligence to obtain payment from the principal. But no satisfactory reason has ever been given why the release of an attachment lien upon the property of the principal should be distinguished from that of any other lien. The mere failure, however, of the creditor to take out and levy an execution or to prosecute a suit which he has commenced against the principal for the debt, no security having been obtained therein, will not release the surety. It has been held that this doctrine of the release of the surety will not be applied in favor of one of the joint makers of an obligation who is in fact a surety for the other makers, for that they were all principal debtors as to the creditor, and that the relation of suretyship existed only as between themselves. But elsewhere it is held to be immaterial whether or not the creditor at the time that he releases the property knows of the relation of his debtors among themselves as principal and surety. If he in fact releases the property of the principal, he does so at his peril. 123. Creditor bound to retain money or property of the principal rightfully in his hands. Whenever the creditor has in his hands money or property of the principal debtor, which he may rightfully retain and apply to the payment of the debt, without violating any duty or subjecting himself to any action, the surety may require it to be so applied. And if the creditor, instead of retaining it, suffers it to pass into the possession of the principal, the surety is thereby to that extent discharged. But this must be property on which the creditor has a lien, to which the surety, on payment by him, can be subrogated. Thus, a corporation which has the option to prevent the transfer of stock by its shareholders who are indebted to it, but has never exercised that option, will not lose its right to hold a surety for an indebtedness of one of its stockholders by allowing the latter to transfer his stock, the surety never having called upon the corporation to enforce its possible lien. A creditor who holds a judgment against principal and surety does not release the surety by employing the principal to do work for him, and then paying the principal for such work in accordance with an agreement to do so, instead of setting it off against his judgment. Nor will he discharge the surety by purchasing property of the principal and paying him for it, before the debt for which the surety is liable becomes due and payable, where, after the contract of suretyship had been made, the principal debtor gave to the creditor, as new security, a mortgage of real estate, under an agreement that the creditor should surrender this mortgage when the debtor should furnish other sufficient security in its place, and afterwards, on the debtor's furnishing the endorsement of a responsible person, the creditor gave up this mortgage. It was held that this surrender of a security did not release the original surety, because the creditor, under the agreement by which he acquired it, had no right to retain it after other sufficient security had been furnished. So, where principal and surety were indebted to a bank on a note which was overdue, and the principal deposited more than the amount of the note with the bank, on the express agreement that this deposit should be applied to meet certain checks which were to be drawn against it, the bank's application of this deposit to the payment of such checks would not release the surety, and the surrender by the creditor of a forged or fraudulent bond or other similar security given to him by the principal debtor, which could not have been enforced against the obligor therein, will not release the surety. In all these cases, if the creditor had preserved the property or means of payment in his own hands, and then collected the debt from the surety, the latter would have had no right of subrogation to these resources, and therefore he was not released by their surrender. Even a payment made to the creditor by the principal debtor, if afterwards avoided and recovered back as a fraudulent preference, has been held not to operate a discharge of the surety. But since, if the principal debtor were insolvent, his set-off against the creditor would be available to the surety, it has been held that an insurance company holding the note of a deceased policyholder for money lent to him, and knowing that his estate is insolvent, is bound to retain the money due on the note out of the amount payable to the administrator of the deceased upon the policy, and its neglect so to do will discharge a surety upon the note. 124. Neglect of a bank to apply deposits of the principal upon his note. How far a release of the surety? It has been held that the neglect of a bank to apply the funds of the principal debtor deposited with itself to the payment of his note due to the bank will discharge the sureties and endorsers upon such note, on the ground that the bank had a lien upon these funds for the payment of the note, which it might have enforced, and which therefore the surety could require it to exercise for his protection. This has, however, been denied on the ground that such appropriation is purely optional with the bank, which cannot be compelled to violate the terms upon which the money was obviously placed in the bank for the payment to the depositor's checks. The bank being the absolute owner of the money deposited, and being a mere debtor to the depositor for the balance of his account, holds no property in which the depositor has any title or right of which a surety on an independent debt of the depositor to the bank can avail himself by subrogation. The true principle is laid down in an English case, that if the circumstances show that a bond given by a depositor to a bank was intended to be a continuing security, the sureties are bound by that intention, and cannot insist upon such an application. Nor can the principal debtor require a bank holding deposee of the surety to apply them upon the debt. 125. Rights of a surety who has paid the debt in ignorance of the creditor's discharge of a security. When a creditor makes an agreement whereby a security is made valueless to a surety who is entitled to be subrogated thereto, and the surety, in ignorance of such agreement, pays the debt to the creditor after judgment recovered against him by the latter, the surety may appropriate any security taken by the creditor in lieu of that so abandoned, or he may recover from the creditor the value of the security which the creditor has thus made valueless to him. This doctrine was laid down under the following circumstances. The Kingston Bank discontinued a suit which it had brought against the maker and endorsers of a promissory note, upon the execution of a bond by 3 of the parties to the note, for the payment of the amount due thereon in 8 months. and this bond was delivered on a secret agreement that the bank would endeavor to collect the amount of the note from those parties who were only liable as sureties thereon, though the primary obligation was upon the obligors in the bond and the other parties to the note. The sureties upon the note, being ignorant of this condition, afterwards paid a judgment recovered against them by the bank for the same debt, and the bank transferred the bond to them. And it was held that the bond having, by reason of the condition made when it was delivered, become satisfied when the bank received payment from the sureties, the latter were in equity entitled to recover back from the bank whatever they had paid on the judgment. But if after the surety has paid the debt to the creditor, the latter collects it again of the principal debtor, the surety cannot then recover back his payment, because this, when made, was rightfully received by the creditor. 126. Instances where surety discharged by creditor's interference with his right of subrogation. The vendor of slaves sold in a lump for a round sum received from the purchaser a note for the price, endorsed by a third person as surety for the payment thereof, and subsequently repurchased some of the slaves from his vendee. And it was held that as the vendor's right of rescission, or lien upon the property for the price, was indivisible, and could not be exercised upon merely a part of the property which had been sold in a lump for a round sum, he had, by his repurchase, destroyed the surety's right of subrogation to this privilege, and so released the latter from his liability. The creditor, having recovered a judgment for the debt against the principal debtor, assigned the same to a third party, together with certain property which had already been owed on the execution and bid in by the creditor, reserving, however, the right to enforce a judgment which he had also obtained against a surety for a part of the same debt. At the same time he gave to the principal a receipt, in which he agreed not to enforce against the latter any claims on the judgment or on the original debt. It was held that by this arrangement the creditor had in effect released the principal debtor from all further obligation to pay that part of the debt for which the surety was liable, and accordingly had exonerated the surety also. A builder agreed to erect a building, for which he was to receive specified sums during the progress of the work, and the balance of the agreed price 60 days after the completion of the building, and gave a surety for the proper performance of his contract. The building having been completed, the owner, although he had received notice of various mechanics' liens, paid the builder the balance of the contract price before it was due under the contract. He afterwards had to pay the amount of the liens, and sued the builder's surety therefor. But it was held that he had exonerated the surety by failing to retain the sums that fell due after he had received notice of the liens. But the mere fact that an agent employed to sell machines on a commission is paid some of his commissions before they are due under his contract will not of itself release a surety upon a bond given by him for the faithful performance of his obligations. A debtor gave to several banks to which he was indebted collateral security of two classes. The first class consisting of notes given for debts due to himself, and the second class consisting of notes made, endorsed, or guaranteed by a surety for his accommodation. By an indenture to which the surety and the banks were parties, he then assigned all his property, including choses in action, to a trustee to pay the debts due to the banks. By the terms of the indenture, the banks were authorized to use their discretion in collecting the notes of the first class, and were to apply their proceeds, when collected, to the payment of his debts due to the banks. The banks were to hold the notes of the second class as collateral security, and not collect them, until the trustee should have disposed of the property assigned to him, and have distributed the proceeds among the banks. The banks, with the consent of the debtor and of the trustee, but not of the surety, made in good faith a compromise with several of the makers of the notes of the first class, so that a balance remained due to the banks after the proceeds of the property assigned to the trustee had been paid to them, whereas if these notes had been collected in full, the banks would have been fully paid. It was held that the banks had discharged the surety, to the extent of the sums given up by their compromise, from his liability on the notes of the second class. The surrender of a leasehold estate by a tenant, and its acceptance by the landlord were held to exonerate a third party from the burden of a mortgage which he had given to the landlord as security for the performance by the tenant of his covenants in the lease, on the ground that the term was a security to which he might have resorted for his indemnity, and which could not have been taken from the defendant without freeing him from his liability, but the same rule would not be applied to a transfer of the lease made by the tenant to the lessor as collateral security merely for a debt, or to a surrender which, though made by the tenant, had not been actually accepted by the landlord. And it has been held in New York that the surrender of a lease and the release of the rent thereafter to accrue will not discharge one who is guaranteed the payment of the rent reserved in a lease from his liability for the rent which is overdue at the time of such surrender. A creditor who held a mortgage from the principal debtor and also a mortgage from the principal's wife as his surety bought of the principal the premises mortgaged by him for a price exceeding the amount of his debt, but did not apply the price in payment of his debt, and it was held that he thereby discharged the mortgage which he had from the surety. For he had rendered unavailing the mortgage given by the principal, to which the surety had a right to be subrogated. So if the purchaser of land which is subject to the lien of a judgment against different persons, one of whom is a mere surety, purchases and takes an assignment of the judgment, he thereby destroys the surety's right of subrogation to such lien, and so discharges the surety pro tanto. But a creditor who holds both the liability of a surety and the security of a mortgage from the principal debtor will not discharge the surety by simply purchasing the equity of redemption from the principal, allowing its full value upon the debt, especially if he makes the purchase in good faith with the purpose of giving the surety the benefit of the mortgage and of appropriating the rents and profits in aid of his liability. For this will not operate a merger of the mortgage, and the surety's right of subrogation will not be impaired. The surety will not be discharged unless his right of subrogation to the securities and remedies of the creditor has been impaired. If the creditor does any act which destroys or impairs the surety's right of subrogation to his mortgages or privileges, or to his remedies against the principal, he thereby releases the surety, even though he has already recovered judgment against the latter. 126a. Surety on bond, not to be discharged by release of security caused by act against which bond taken. A surety on a guardian's bond cannot claim that he is discharged from liability by reason of his having given up security that he held, in reliance upon acts of the ward induced by the fraudulent actions of the guardian against which the bond was intended to be a security. Where such a surety had taken a mortgage from the guardian as a protection against his liability, and then discharged this mortgage in reliance upon a receipt in full given by the ward after coming of age to the guardian, but it appeared that the guardian had fraudulently obtained this receipt from the ward, who was of feeble mind, by misrepresentations of its character. It was held that the ward could still hold the surety upon the bond. For the ward owed no duty to the surety, but the surety had undertaken for the fidelity and honesty of the guardian towards the ward, and so could not avail himself of the receipt obtained from the ward by the mere fraud and circumvention of the guardian, even though by means of the same receipt the guardian had procured his discharge from the court to which he was accountable. The surety on a bond given by a contractor to a city to pay laborers employed by the contractor on the city's work cannot complain that money earned upon the contract was paid according to its provision by the city to the contractor. 127. Surety not entitled to subrogation until the whole debt paid. The right of subrogation does not arise in favor of a surety until he has actually paid the debt for which he is liable as surety. The right does not accrue upon a partial payment by the surety until the creditor is wholly satisfied. Even if a surety is liable only for a part of the debt, and pays that part for which B is liable, he cannot be subrogated to the securities held by the creditor until the whole demand of the creditor is satisfied. Where the surety is allowed by bill in equity after the debt has become due to compel the creditor to enforce his demand against the principal debtor, yet he cannot be subrogated to the creditor's liens, securities, and equities for the debt until he has actually paid it. So, the endorser of a promissory note, which is payable on time and secured by a mortgage of the principal's real estate, who has been compelled by the mortgagee to pay the interest which has become due thereon, cannot enforce the mortgage for his indemnity, while the note remains the property of another holder and the principal sum is still due thereon. The payment need not be in one sum, but may be made at different times, nor need it be wholly, or at all in money, if the creditor accepts something else. Though, as has been already stated, if it be not in money, the surety's right will extend only to his reimbursement for the real value of what he has paid. It has been held in Missouri that a surety for part of the indebtedness of his principal becomes entitled, by paying the part for which he is liable, to a pro rata or proportionate share of the proceeds arising from a sale of the debtor's property, and may be subrogated accordingly to the rights of the other creditors, so as to have the benefit of all their securities. But this is contrary to the general doctrine. But if the effect of the surety's subrogation would be to give him a lien upon the property of the creditor himself, so that he would be entitled to immediate repayment from the creditor's property, then, to avoid certity of action, the right may be enforced in the creditor's suit against the surety, without waiting for actual payment. 128. Satisfaction is creditor right. It need not come wholly from surety. It is the creditor who is entitled to satisfaction, and neither the debtor nor any other creditors can object to any arrangement between the surety and the creditor for the subrogation of the surety, whether the latter has or has not completely satisfied the debt. If the creditor accedes to the request of the surety for the enforcement of the collateral security, this will be ordered. If the surety has satisfied the creditor partly by a set-off of the creditor's own obligations or otherwise and only partly in money, his right of subrogation will yet extend to the whole of the indebtedness which he has satisfied. If the principal debtor has himself paid part of the indebtedness, and the surety only the balance, yet, when once the creditor is wholly satisfied, the same principle of equity which substitutes the surety who has paid the whole debt to the place of the creditor will equally protect the surety paying a part thereof to the extent of his payment. A partial payment is sufficient to establish the surety's right as against the principal, or any one standing in the place of the principal. It is only the creditor who can insist that the debt must be paid in full, nor need the surety's payment be made in money. Whatever is accepted by the creditor as a payment, so as to discharge the principal debtor from his liability, will operate as a payment in favor of the surety. But until the creditor has been paid in full, the surety cannot, against the will of the creditor, in any manner interfere with the latter's rights or securities, so as to put him to any embarrassment in collecting the remainder of his demand. If the surety has made partial payments upon a debt secured by a mortgage from the principal debtor, then upon foreclosure any surplus proceeds over the amount needed to pay the creditor in full must be applied to repay the surety. 129. Creditors' right to apply security held for several debts until all are satisfied. A creditor who holds security without special stipulations as to its application, for various sums due to him from high debtor, for some of which he also holds sureties, may, in case of the insolvency of the principal and of some of the sureties, apply the proceeds of the security upon such of the debts as may be necessary for his own protection, and solvent sureties upon others of the debts cannot in any way avail themselves of such security in equity without paying or offering to pay the whole of the debts for which the security was given. So, where a debtor mortgaged two estates to a creditor as security for the payment of two distinct sums, with a surety for the payment of one of the sums only, the right of the creditor to retain both securities until the payment of both debts will override the right of the surety, upon his payment of the debt for which he is surety, to have the benefit of the security pledged for that debt. And where the principal debtor gave to his creditor both a mortgage and a covenant by a surety to secure the payment of the debt, and then gave the creditor a further charge upon the mortgaged property to secure a further loan, it was held that the surety was not entitled to the benefit of the first mortgage without paying the second loan as well as the debt for which he was surety. But this decision has since been overruled, on the ground that the creditor could not thus derogate from the rights of the surety, being aware of the facts which create those rights. As the doctrine of subrogation is founded upon reason and justice, and not upon any contract or stipulation between the parties, it follows as a necessary consequence that the surety is not to be substituted to the place of the creditor, unless upon the circumstances of the case it is shown to be just and proper that he should be. To become entitled to such substitution, he must first pay the whole of the debt or debts for which the property is held by the creditor. For it would be manifestly unjust, and a plain violation of the creditor's rights, to compel him to relinquish any portion of the property before the obligation for the performance of which it had been conveyed to him has been fully complied with. If a creditor holding a claim for which he has both collateral security from the principal debtor and also the engagement of a surety acquires an additional claim against the same principal, to which the agreement upon which the security was taken does not extend. The surety will be entitled to the benefit of such security on payment of the first indebtedness alone, and can require the proceeds of such security, when realized by the creditor, to be applied upon the first indebtedness. For the surety's right of subrogation, when once vested, cannot be interfered with by the act of the creditor alone. 130. Surety may come into equity to compel payment of the debt by the principal. A surety, after the debt has become due, although he has not paid it, may, if the creditor refuses or neglects to enforce his demand against the principal debtor by proper legal proceedings, come into equity, bringing both the debtor and the creditor before the court, and have a decree compelling the debtor to make payment, and thus to exonerate the surety from liability. And the creditor, being first fully indemnified, subjected to no delay, and exposed to no risk of loss, may, upon such a bill, be compelled to resort to the property of the principal for the satisfaction of his claim before coming upon the surety, and the surety may have any property which has been specifically appropriated for the payment of the debt by, or for the principal debtor applied thereto for his indemnity, but this is strictly the right of the surety, and is not for the benefit of the principal. So the surety may, for high relief, have the debt proved against the estate of the principal in bankruptcy. But the surety cannot ask for the use of the securities and remedies held by the creditor to enforce payment from the principal, without indemnifying the creditor against any costs and expenses. Nor has the surety any implied authority to sue the principal in the name of the creditor. And when sureties who are claiming in a court of equity the benefit of subrogation have not yet paid the creditor, though a judgment has been recovered against them, it has been held that the court may, in the exercise of its equitable jurisdiction to declare future rights and duties, order that the sureties be subrogated to the rights of the creditor when they shall have paid the debt, and may in the meantime protect the surety. 130a. Equitable relief given to the surety. In equity, relief may also be given to a surety for his protection out of the property of his principal, so far as the surety's equitable rights can be maintained without injury to the creditor, either by granting an injunction against the sale of the surety's property until property pledged by the principal for the debt shall first have been applied for its payment, or by subrogating the surety to the creditor's rights against the principal, or by marshalling the securities available and applying them to the satisfaction of the debt in the order in which they are equitably chargeable, according to the circumstances of the particular case. Even after a judgment at law against principal and surety, equity will still protect the surety so far as this may be done without prejudice to the paramount rights of the creditor, but no farther. If upon a writ of error the principal gives new sureties and supersedes the judgment against himself, the creditor may be restrained from taking out execution against the surety, pending proceedings upon the writ of error. The property of both husband and wife being mortgaged to secure the debt of the husband, she was allowed on foreclosure to have the husband's property first sold and applied on the debt, and if the creditor, having taken out execution against both principal and surety, levies upon the surety's land, and this is purchased at the execution sale by the principal, then, by reason of the duty incumbent upon the principal himself to pay the judgment, his purchase will inure to the surety's benefit, and he cannot hold the land against the surety. 131. Rights of successive sureties to subrogation against each other. The mere fact that two or more persons are sureties for the same debt will not give them equal rights against each other, unless their liability is the same in kind and degree. Not separate and successive, but joint and coordinate, so that all stand in equality jure in regard to the payment of the debt for which they are respectively liable. A surety who first becomes such in an obligation incident out to the prosecution of a legal remedy against the principal will, upon paying the debt, be allowed to stand in the creditor's place only as to his remedies against the person or property of the principal. As to any prior surety or any prior interest in property which may be pledged to the creditor for the debt, he must occupy the position of the debtor. He cannot claim to be subrogated to the rights of the creditor against any prior sureties. On the contrary, the prior surety, if compelled to pay the debt, will be subrogated against the subsequent surety. Those who last become sureties do so, not only for the benefit of the creditor, but in exoneration of the former sureties, and will be liable to indemnify such former sureties. Accordingly, if after a judgment against two, one of whom appears by the record to be a surety only, a third party intervenes, solely at the request of the principal, and becomes bail for the stay of execution, taking indemnity from the principal therefore, and at the expiration of the stay the original surety is compelled to pay the judgment, he may, by subrogation thereto, recover the amount thereof from such bail. One who becomes surety for the principal in the course of legal proceedings against him has no right of contribution against a prior surety for the debt. But, on the contrary, the latter is entitled to be subrogated to the creditor's rights against him, as in the case of bail. The rights of a surety on a second appeal must yield to those of a surety on the first appeal of the same case, both being sureties for the same principal. And one who, by becoming a surety on a judgment bond, has prevented a sale of the debtor's property, will not be substituted to the lien of the creditor, so as to overreach a junior lien created before the surety became liable. Nor can such a subsequent surety, after having paid the judgment, claim by subrogation the benefit of a mortgage given by the principal debtor to the original surety for the latter's indemnity. But after the subsequent sureties who are primarily liable have been held for the full amount for which they became bound, the earlier sureties will be liable on their obligation for any deficiency. Their right is merely to be preferred to the subsequent sureties. 132. Rights of one who becomes surety for the payment of a judgment. Where the payee of a promissory note commenced a suit against the three makers thereof, and pending the suit made an agreement with one of these makers, by which was to pay a certain sum upon the note, and the creditor should take judgment for the balance against the three, but should not enforce his judgment against made the payment accordingly, and the creditor subsequently collected his judgment from the bail of another of the defendants, and in pursuance of an order of the county court, the bail took an assignment of the judgment from the creditor, and subsequently collected the amount of this judgment from It was held that the creditor was not responsible for this act of the bail after the assignment of the judgment had been made by order of the court, and that it could not maintain an action against the creditor upon the agreement not to enforce payment from him. And Redfield J. said that the county court had no power to order such subrogation of the bail to the rights of the creditor, and that at most the bail by such subrogation could acquire only those rights which the creditor had, and must take the judgment subject to the creditor's agreement, not to enforce collection thereof against though A's only remedy to enforce compliance by the bail with this agreement would be in equity, where the original principal in the debt prosecuted a writ of error, which was overruled, and the surety or endorser of the note afterwards paid the debt, he was subrogated to the judgment rendered on the writ of error against the original defendants and the sureties on the supersedeas bond, upon the general principle that the surety is entitled to all collaterals, and that the second sureties may, by becoming such, have put him in a worse condition. And the court said that the latter sureties, having, at the instance of the principal, stipulated to pay the debt, suffered no injustice in being called upon to do so, since they were obliged to do no more than they undertook, and had no right to complain that they were not allowed to use as a payment by themselves the money which proceeded from another person, whom their principal was previously bound to save harmless. If the interposition of the second sureties may have been the means of involving the first surety in the necessity of paying the debt, the equity of the first surety will decidedly preponderate. If the interposition of the bail or the surety for the judgment is the means of hindering or delaying the payment of the debt, such second surety has less equity than a prior surety. The coming in of the bail, by delaying execution, may have prevented a payment by the debtor or out of his funds. As between the bail and the principal debtor, or those whose rights have accrued under him, the former may be subrogated to the rights of the judgment creditor. But regard must always be had for third persons whose rights might be affected by such subrogation. 133. Where later surety la surety for original sureties as well as for principal. If, however, the subsequent surety can fairly be regarded as a surety for the original sureties as well as for the principal, then he may be subrogated against the original sureties as well as against the principal. Thus, where, after the recovery of a judgment against both principal and sureties, a third person becomes surety for the payment of the debt, upon the creditor's promise to give him the benefit of the judgment for his satisfaction and indemnity, such new surety has a superior equity over the old sureties, and may after payment enforce the judgment against them for his own protection. His agreement made him the conditional assignee of the judgment. The same principle has been applied to the sureties upon bonds and notes. So, if a judgment against two is affirmed on their appeal against them, and their surety on the appeal, and on further appeal is again affirmed against the three and their surety on the second appeal, the first and second surety are related to each other, not as co-sureties, but as principal and surety. And if the first surety pays the final judgment, he has no recourse against the second. And if a judgment against a principal debtor and his sureties is superseded by the defendants with two others as their sureties, all the defendants in the original judgment are principals as to the sureties in the supersedeas judgment. 134. Exceptions to usual rule of subrogation between successive sureties. In Louisiana, it has been held, contrary to the general rule, that the second surety is entitled to subrogation against the first surety, on the presumption that the second surety was induced to bind himself in consequence of the responsibility of the principal having been guaranteed by the first surety. And accordingly the surety in an appeal bond, after paying the amount of a judgment against his principal, was allowed to enforce the judgment against the original bail in the suit for the whole amount so paid by him. A like decision was rendered, under special circumstances, in Missouri. In Virginia, a surety who becomes such in the course of judicial proceedings for the collection of the debt from the principal is subrogated like any other surety for the debt to all the remedies of the creditor, even against third persons, whose rights, though subject to the creditor's lien, have accrued before the obligation of the surety was entered into. He will be subrogated to the creditor's judgment lien upon lands alienated by the debtor. After the judgment, but before the surety became such, where, on an appeal from a judgment, a new judgment was rendered for a much larger sum, and was paid by the surety in the appeal bond, this surety was subrogated to the creditor's judgment lien against mean purchasers of the debtor's real estate, not only for the amount of the original judgment, but also for the increased amount which the surety had been compelled to pay, and the original surety cannot have contribution from sureties given in the course of subsequent litigation. But a judgment surety for the principal debtor will not be subrogated to the creditor's lien upon the property of one who stands in the position of a prior surety for the judgment debtor. In Maine and Massachusetts, it has been held that the doctrine of subrogation is not applied at all as between successive sureties taken in the course of judicial proceedings against the principal debtor, and neither the prior nor the subsequent surety is allowed any remedy at law against the other. And in Maryland, the principles of contribution between co-sureties are not to be applied to such successive sureties. 135. Whether original obligation extinguished by surety's payment thereof, rule in England. Although it is a general rule that in equity a surety is subrogated to the benefit of all the securities for the debt which the creditor holds against the principal, yet it was finally settled in England that this subrogation must be limited to such securities only as continue to exist and are not ipso facto extinguished by the act of payment, and that payment of a bond or other specialty, or of a judgment executed by or recovered against both principal and surety, or the principal alone, extinguish the obligation so as to prevent any subrogation of the surety thereto. But the technical reasoning of these decisions, never entirely satisfactory, has now been done away with in England by a statutory provision that every person who, being surety for the debt or duty of another, or being liable with another for any debt or duty, shall pay such debt or perform such duty, shall be entitled to have assigned to him, or to a trustee for him, every judgment, specialty, or other security, which shall be held by the creditor in respect of such debt or duty, whether such specialty, judgment, or other security shall or shall not be deemed at law to have been satisfied by the payment of the debt or performance of the duty. And such person shall be entitled to stand in the place of the creditor, and to use all the remedies, and if need be, and upon a proper indemnity, to use the name of the creditor in any action or other proceeding at law or in equity, in order to obtain from the principal debtor, or from any co-surety, co-contractor, or co-bidder, as the case may be, indemnification for the loss sustained and advances made by the person who shall have so paid such debt or performed such duty. and such payment or performance so made by such surety shall not be plead able in bar of any such action or other proceeding by him, provided always that no co-surety, co-contractor, or creditor shall be entitled to recover from any other co-surety, co-contractor, or creditor, by the means aforesaid, more than the just proportion to which, as between the parties themselves, such last-mentioned parties shall be justly liable. This statute will be applied to protect a co-surety or creditor from whom the creditor has coerced payment on execution, and is held to be applicable to a contract made before the passage of the statute, where the breach of the contract has taken place, and the payment by the surety or creditor has been made after its passage, and the right of a surety who has paid a judgment obtained by the creditor against the principal debtor, and all the sureties to stand in the place of the judgment creditor, will not be diminished by the fact that he has not himself paid the whole judgment. 136. Present English rule generally adopted in the United States. With more or less aid from legislation, the rule laid down in this statute has been pretty generally adopted in the United States, and the distinction that equity will not subrogate the sureties in those cases in which payment discharges or extinguishes the security at law, such as bonds and judgments which bind the principal and the surety jointly, or bonds or judgments which constitute or merge the debt, although the surety be not bound by them, has been generally denied in this country. As was said by Nisbet J. in deciding that a surety who had paid a bond debt of his principal was, by subrogation to the rights of the creditor, entitled to rank as a specialty creditor of his principal, the substitution of the surety is not for the creditor as he stands related to the debtor after the payment, but as he stood related to him before the payment. He is subrogated to such rights as the creditor then had against the principal, one of which unquestionably was to enforce his bond against the principal, and if he was insolvent, to be let in as a bond creditor. What difference is there between permitting the surety to reimburse himself out of a mortgage lien held by the creditor, and permitting him to take out of the estate generally of the debtor the amount that he has paid? If he realizes upon the mortgage, he abstracts the amount which he has paid from the estate of the principal. If he realizes on the bond, the mortgaged property goes back into the common fund, and the result to him and the other creditors is the same. The very fact that the surety could not enforce the bond at law is a reason in equity why he should be allowed to come into the distribution as a bond creditor. But the recovery of a judgment in one state upon a judgment previously recovered in another state, or in another court, has been held so far to extinguish the first judgment that a surety cannot, upon paying the later, be subrogated to the earlier judgment. 137. Right of surety to be substituted to the benefit of the original obligation maintained. In the following states, this right of the surety has been more or less distinctly affirmed. In New Hampshire, it is held that though payment of a joint debt by either of the debtors is a discharge of the debt, and of any action, judgment, or execution, founded upon it, yet, if the debt is paid by a surety, and the creditor upon his payment assigns to him any collateral security, the debt will be regarded as still subsisting and undischarged, so far as is necessary to protect the security, and an attachment of the property of the principal in an action pending for the recovery of the debt is such a collateral security. And accordingly the surety, after his payment, may take an assignment of such an action, prosecute it to judgment, and take out execution thereon for his own use. And if a joint and several promissory note is taken up by one of the signers thereof, who is merely a surety, not with the intention to pay and discharge it, but to purchase it, this will not be a discharge of the debt, and an action may still be maintained upon the note in the name of the payee for the benefit of the real plaintiff. Nebraska. The New Hampshire rule as to an attachment pending against the principal when payment is made by a surety has been followed in Nebraska. The surety may, upon proving his suretyship in the original action, but not otherwise, have a judgment against his principal and himself assigned to himself on his payment, and enforce it against the principal for his own indemnity. In New York, a surety upon the performance of his contract is entitled to the original evidences of indebtedness held by the creditor, and to any judgment in which the debt has been merged. The surety has not only a right of subrogation pure and simple, but may also demand an assignment from the creditor, and though the obligation is discharged so far as the creditor has any interest therein, yet the original debt is kept alive for the benefit of the surety against the principal debtor. A surety paying a judgment against himself and his principal has the right to have it assigned to himself, and may then enforce it against the principal or his estate. This rule, originally restricted to equity, is now applied also at law. In Pennsylvania, a surety who has paid a debt secured by a judgment against his principal, and who is in other respects entitled to subrogation, may revive the judgment without first obtaining a decree of substitution, and may have his rights tried on a sire facies, even though an entry of satisfaction has been made upon the judgment, if this was not done at the instance of the surety. Actual payment discharges a judgment or other encumbrance at law, but where justice requires it, it is still kept on foot for the protection of the surety who has paid it. He will be subrogated to all the creditor's rights in the original obligation which he has paid, not only against his principal for indemnity, but against his co-sureties for contribution, and not only to the benefit of a direct obligation, such as a judgment or pending action, but of such an incidental remedy as a distress for rent. The surety will need no formal assignment. In New Jersey, a co-defendant who has been compelled to pay a judgment upon which the other defendant was primarily liable may have the benefit and control of the judgment and execution for his reimbursement against his co-defendant, the primary debtor. The rights of the parties are settled by statute. In Delaware, the surety upon a bond may, on tender of the debt, demand an assignment of the bond, that he may enforce it against the principal. He is entitled to the original evidences of debt, and to any judgment in which the debt has been merged, as well as to all collateral securities held by the creditor. In Maryland, a surety, upon paying a judgment debt of the principal, may in equity compel the creditor to assign to him the judgment, with all liens given by the principal debtor to secure its payment. The payment in full by the surety will of itself operate, if not at law, yet in equity as an assignment, so as to enable him to use the name of the creditor for the recovery of the money from the principal, or to levy the execution for his own use upon the property of the principal. And though a partial payment by the surety will not operate as an assignment pro tanto, so as to give him any control over the judgment or execution, yet it will not discharge the principal to the prejudice of the rights of the surety, without the latter's consent, and will give the surety, to the extent of his payment, an equitable interest in the judgment, which he may release or transfer. But to entitle a surety to an assignment as against his co-sureties, he must not only satisfy the original judgment, but must himself pay the whole amount of it. In Virginia, the surety's payment of a judgment against himself and his principal does not extinguish the judgment, as between the principal and the surety, but the surety will be subrogated to all the liens and remedies which the creditor had by reason of his judgment, and which have not been already lost. And the same rule is applied to specialties or other obligations. Nor will the surety lose this right by having taken other security from his principal. In North Carolina, a surety who pays a judgment for the debt recovered against his principal may have the judgment assigned to a trustee for his reimbursement, and may pursue the bail of his principal, even though a receipt be given by the creditor to the principal. But the surety, to protect his rights, must take such an assignment. If he does not, the debt will be extinguished, both as to his principal and himself, and the assignment must not be made to himself, but to one who is not a party to the record. Such an assignment will preserve the original obligation, and enable the surety to enforce all the remedies which the creditor might have used against the principal, and the surety may control the judgment even against the nominal assignee. The surety upon a specialty debt, who has paid it, will be deemed a specialty creditor, both of his principal and of his co-sureties. But the surety's right, if contested, can be enforced only in an independent action. A mere joint debt 0R has not the same equity of subrogation against his associates that a surety enjoys against his principal. In South Carolina, a surety who pays a judgment recovered against himself and his principal, or a specialty executed by himself and his principal, does not thereby extinguish it, but may in equity enforce it against high principal's estate, though this privilege has been denied as between co-sureties. But the lien of a judgment which has been paid by one surety has been kept alive for his protection against the insolvent estate of his co-surety. Where after separate judgments against principal and surety for the debt, The latter paid the judgment against himself, and thereupon the sheriff entered satisfaction upon both judgments. The surety was allowed to vacate this entry upon the judgment against the principal, and to set it up as a lien upon his estate. The same right of subrogation has been allowed to a son who, at the request of his father, has paid a judgment against the latter. In Georgia, a surety who has paid the debt of his principal is, in equity, subrogated to all the remedies of the creditor, and is entitled to occupy the place of and be substituted for the creditor upon the original evidence of the debt, and the surety upon his payment of the debt may require an assignment thereof from the creditor. If a surety pays a judgment rendered against himself and his principal, he is entitled to control such judgment and the execution thereon, and this right will pass upon his decease to his personal representatives. But this right is in equity, not at law, and where, pending a suit brought jointly against the maker and the endorser of a promissory note, the endorser paid the note, it was held that this payment, made before judgment, barred the further prosecution of the suit, even at the instance and for the benefit of the endorser. His remedy was by action in his own name, and this right of subrogation to the original indebtedness is allowed only to a surety. It will not be extended to a mere joint debtor. This right of subrogation is affirmed and regulated by statute. In Ohio, a surety who pays a judgment rendered against himself and his principal will be subrogated to the rights therein of the creditor. This payment will not operate as an extinguishment of the judgment for the benefit of the principal. If one of several co-sureties pays a judgment against them, with the intention of saving his right to be subrogated to the remedies of the judgment creditor, he may afterwards be subrogated to the judgment, notwithstanding its legal extinction, and such intention on his part will be presumed from the bare fact of payment until the contrary is shown. The remedy against the co-surety is limited to 6 years like a simple contract. That against the principal is extended to 10 years. In Kentucky, a surety advancing to the creditor the amount of a judgment against his principal may stipulate for substitution, and the control of the judgment and execution against his principal for his reimbursement, and a court of law will protect him therein, and under the statutes a surety, upon paying the amount of a judgment against himself and his principal, may compel the creditor to assign the judgment to himself. So, if the surety has paid a preferred debt of the principal, he is entitled to the benefit of the preference. But the surety of an intestate who has paid a judgment or specialty debt of his does not thereby become ipso facto, and without an assignment, a judgment or specialty creditor of the estate. He is prima facie a simple contract creditor merely. In Tennessee, though payment by a mere joint debtor discharges the original obligation, a surety who pays a judgment against his principal is subrogated to the judgment lien and to all the rights of the creditor against the principal. Even a partial payment by the surety will give him pro tanto the rights of a judgment creditor as against his principal. The payment by the surety, though it may destroy the remedy or extinguish the security so far as the creditor is concerned, has not that effect between the principal and the surety. As to the surety, it operates in equity as an assignment of the debt and of all legal remedies upon it, and in his favor the debt and all its legal obligations are regarded as subsisting. The surety is not so far subrogated to the rights of the judgment creditor that an execution can be issued on the original judgment in his favor as an assignee of the judgment, but he may be substituted to the lien which the judgment creditor had upon the property of the principal and to all the remedies of the creditor, and by contract with the creditor, the surety may after paying the judgment cause the execution to be enforced against the principal debtor. In Mississippi, under the former statutes, a surety who had paid a judgment for his principal was in equity entitled to be subrogated to all the rights of the creditor in the judgment. But at law his payment extinguished the judgment, and he became merely a simple contract creditor of the principal. The present statute protects the rights of the surety at law, and he is subrogated to the judgment lien and to all the rights of the judgment creditor, and may take out execution upon the original judgment. This subrogation takes place by operation of law upon the surety's payment, without any entry upon the judgment roll or elsewhere. Nor will the surety's judgment lien upon the lands of the principal debtor, even in the hands of bona fide purchasers thereof, be affected by the fact that upon his payment the judgment was marked settled by the plaintiff's attorney upon the judgment roll and execution docket if the entry was made without the surety's authority or consent. In Alabama, though it was first held that an execution against the principal might be enforced for tile benefit of a surety who had paid the judgment, it was afterwards considered that the surety could not after his payment keep the judgment alive against either his principal or his co-sureties, that even though he took an assignment of the judgment he would have no remedy at law, except as a simple contract creditor of the principal, that he could assert no lien by virtue of the instrument upon which he had been surety, as that became functus officio by payment of the debt which it secured. But it is now provided by statute that the surety upon paying such a judgment may have it assigned to himself, and may enforce it for his indemnity against the principal debtor, at law or in equity, as fully as the creditor himself might have done. In Michigan, the payment of a judgment by a surety with the intent to avail himself, by subrogation, of the lien of the judgment, will not in equity extinguish the debt or destroy the force of a levy upon the execution. Equity will enforce the right of subrogation by keeping the debt alive and preserving the force of the levy for the protection of the surety. In Iowa, the surety on his payment is in equity subrogated to the rights of the creditor in the original obligation, and may enforce the same as of the class to which it originally belonged. But at law his payment of a judgment extinguishes it, and his right of subrogation is not available until enforced by proper legal proceedings seasonably brought. He may take an assignment of the original obligation and then enforce the creditor's right. In Indiana, though the surety may enforce all the rights of the creditor in the original obligation by having it properly assigned to himself, yet when a judgment is rendered jointly against two, they are both to be regarded as principals, until one of them is shown to be a surety for the other. And when one of such defendants, claiming to be merely a surety, but without any judicial determination as to his suretyship, pays the judgment, he cannot have execution thereon for his own use. The surety should establish his right by proper proceedings in the original suit or by subsequent proceedings, then he may be subrogated to the creditor's rights after paying the debt. In Wisconsin, a surety upon paying a judgment against himself, his principal, and his co-sureties may be subrogated to the creditor's rights therein, against the principal for the full amount of the debt, and against the sureties for their proportions thereof. The judgment lien may be kept alive against the other judgment debtors, either for reimbursement or for contribution. In Minnesota, a surety who has paid a judgment against his principal and himself may not only maintain an action at law against his principal in his own name, but may also enforce the creditor's original judgment lien against the principal debtor. In Kansas, by statute, sureties who have paid a judgment rendered against their principals and themselves may take an assignment from the judgment creditor and enforce the execution against their principals. In Illinois, the surety, upon paying a judgment against his principal, may take an assignment of it and have it kept alive for his benefit, and may enforce all the securities held by the judgment creditor. He has an election to keep the judgment alive against his principal or to treat it as extinguished and sue his principal for reimbursement. If he takes an assignment to a third person, he must, before enforcing execution against a co-defendant, procure and file an assignment to himself. In Missouri, a surety who pays the debt of his principal is entitled to an assignment of the instrument paid. Though his payment extinguishes the obligation so far as the creditor is concerned, this will not affect the rights which the surety has acquired by his payment. It still subsists for his benefit as against his principal, but the fact of suretyship must be judicially established. His remedy is not a matter of course, so the lien of a judgment, though satisfied by one surety, will in equity be kept alive as between co-sureties. In Arkansas, when a surety pays a judgment rendered jointly against his principal and himself, it is extinguished at law, and the surety can avail himself of it against his principal only in equity, nor can it be kept alive against a co-surety. In Texas, the surety, upon his payment of the debt of the principal, is entitled not only to the benefit of all the securities, both legal and equitable, which the creditor holds in pledge for the debt, but to be substituted for the creditor as to the very debt itself, and to have this assigned to him. And equity will regard that which ought to be done as done already, where this is necessary to sustain an action. If the creditor had a first attachment on the principal's property, the surety after payment is entitled to this. But the issue of suretyship must be made and settled in the original suit. In Louisiana, though it is considered that at the common law a surety would not be subrogated to the rights of the creditor upon his paying a joint judgment against himself and his principal, but that the judgment would be extinguished by such payment, yet under their code a surety who pays a judgment recovered against the principal debtor is thereby subrogated to the rights of the creditor, and may issue an execution on the judgment in the name of the creditor for the recovery of the amount which as surety he has paid. And since the surety has an equitable interest in the payment of the demand by the principal, the creditor may permit an execution to issue at the instance of the surety. In California, one of two co-defendants paying the whole of a judgment against them is entitled to be subrogated to the rights of the plaintiff in the judgment to the extent to which his payment accrues to the benefit of his co-defendant. But this right does not arise until he has fully satisfied the judgment. An assignment, however, though made before maturity, of a joint and several promissory note to one of its makers from the payee thereof, constitutes a payment and discharge of the obligation. 138. Right of tile surety to be subrogated to the benefit of the original obligation denied. On the other hand, it has been maintained in some jurisdictions that, although the surety is entitled, upon his payment of the debt, to take by subrogation all the securities which the creditor held for the debt, this does not mean that the original obligation, which is discharged by the payment, shall be assigned to or vested in the surety, but refers only to such securities as are collateral to the principal obligation. A judgment against principal and surety is taken to merge that relation between the debtors, and cannot, after a payment by the surety, be kept alive against the principal for the benefit of the surety. This rule is followed in Vermont, where it is held that when a debt is paid, though by a surety, all liens and securities taken or obtained in legal proceedings to enforce its collection are also extinguished. The original obligation is extinguished as to all the debtors by one debtor's payment thereof. In Massachusetts, a debtor, whether principal or surety, who pays a debt for which others are bound with him, thereby extinguishes its obligation and can obtain indemnity or contribution from the other debtors only by an independent action against them. The original debt is extinguished, and no further action can be maintained upon it, though the transaction be in form of purchase and an assignment be made of the debt. In Maine, the same rule prevails as that adopted in Massachusetts. In Nevada, a surety who has paid a note and had it assigned to himself, though he may maintain an action against the principal debtor for his payment, has no remedy upon the note itself. But the rule generally adopted, except in these states, is that a payment by a surety does not necessarily in equity extinguish the original obligation as between the surety and his principal, but only so far as the rights of the creditor are concerned. 139. Indemnity belled. By a surety discharged by his release from liability. A mortgage given to the surety for his indemnity by the principal debtor is extinguished by the surety's discharge from liability. If the original debt is paid and the surety accordingly discharged by the execution of a new note with a new surety, such a mortgage is extinguished, and it cannot be kept alive by an assignment thereof to the new surety. Though a contemporaneous verbal agreement between the mortgager, the mortgagee, and the new surety that a mortgage of personal property should stand as security to the new surety might of itself, as between the parties, constitute a valid mortgage of the property. If a surety who holds such a security becomes indebted to his principal upon a different transaction, and in consideration thereof assumes the payment of the debt for which he was a surety, this arrangement will release the security in his hands. But a mortgage given to a surety for his indemnity was allowed to pass to a third person who paid the money for the surety on the faith of an agreement that the mortgage should be assigned to him. And if the note which constituted the original indebtedness is, after protest for non-payment, paid out of the proceeds of a new note made by the mortgager and endorsed by the mortgagee for that express purpose, the mortgage will not thereby be discharged, but will continue in force as a protection to the mortgagee against his liability upon the second note. The mere change in the form of the debt does not discharge the security. 140. Right of subrogation among co-sureties. One of two or more co-sureties who has paid the debt to their common creditor may he subrogate to the rights of that creditor against his co-sureties, to enable him to recover contribution from them. He will be subrogated as against his co-sureties in most of the states, as in England under the Mercantile Law Amendment Act, to all the rights of the creditor, and entitled to enforce all the creditor's liens, priorities, and remedies, as well against his co-sureties as against the principal debtor. This right will pass to the creditors of a co-surety whose means of obtaining their demand have been lost by their debtor's property, upon which they had a subordinate lien, having been taken to pay the whole obligation of which his co-sureties should have paid a part, and to a grantee of one of the co-sureties, who, to save the property which he has purchased, has been obliged to pay a judgment which was a lien upon the property of all the sureties, against both the co-sureties themselves and their grantees of the other property upon which the judgment was also a lien. One surety in a joint and several obligation, in which there was a warrant to confess judgment, having paid the whole indebtedness, may enter judgment upon the obligation to his own use, and have execution against his co-surety for the latter's proportion. One of two co-sureties who has paid the full amount of a civil recognizance will be allowed to use the recognizance for the purpose of recovering out of the estate of his co-surety 1/2 of the sum so paid by him, if one surety has received property or security for or to be applied upon the debt, and another surety is then compelled to pay the whole debt. The latter can follow this property in equity and have the benefit of it, or he may at law recover its value from the surety who has received it. In Massachusetts, the enforcement of this rule has been refused at law, but it is fully recognized as a doctrine of equity. 141. Co-sureties entitled to the benefit of securities held by each other. A fund deposited by the principal debtor with one of his sureties as a security against the latter's liability will inure proportionally to the benefit of all the co-sureties. In the absence of special circumstances, all the sureties are entitled to share in the benefit of any indemnity which their co-surety may have taken from the principal debtor, even though such indemnity may have been intended by the principal for the benefit of the latter surety alone. Any security given to one surety and conditioned for the payment of the common indebtedness will inure to the benefit of all the co-sureties. Persons who are subject to a common burden stand to each other upon a common ground of interest and of right, and whatever indemnity is furnished to one of them by him, for whom the burden is assumed, must be applied equally for the relief of all the associates. If one surety gets possession of a fund belonging to the principal, he may not take the entire benefit of it, but must share it with his co-sureties. If one who is a surety for the same principal on various liabilities, on some of which he has co-sureties, takes from his principal security generally for his protection, this is, for the benefit of his co-sureties, to be apportioned among all the demands pro rata. But if one surety takes from his principal a mortgage for his protection against a particular debt, this will inure to the benefit of his co-sureties on that debt, and the mortgagee will have no right to apply the proceeds of the security to the payment of any other debt, to the prejudice of his co-surety. To prevent circuity of action and attain the ends of natural justice, a court of equity will completely indemnify one of the sureties upon a bond by means of a lien upon the property of the principal existing in favor of another surety, notwithstanding the former surety has himself relinquished another lien upon the same property, originally created for his indemnification. A mortgage executed to one or more of the sureties upon the official bond of an officer will inure to the benefit of all the sureties, as well those who subsequently become such under a proper and lawful order of court requiring additional sureties upon the bond, as those who were sureties at the date of the mortgage. The same rule will be applied to property or securities deposited by one co-surety with another for their joint benefit, as to securities furnished by the principal. Each is entitled to his proportion, and only to his proportion thereof. 142. A. Surety cannot have contribution from his co-sureties without accounting for such security. A surety who, being indebted to his principal, or having received property or security from the principal, has paid the whole debt, cannot require contribution from his co-sureties without showing that this indebtedness or security has been properly disposed of, and is insufficient to satisfy the debt for which contribution is demanded. If he has appropriated the security to himself by means of a collusive sale, he must account for it at a fair value. If the security has not yet been disposed of, his remedy is in equity. But if the surety who has paid the debt has received only a partial indemnity from his principal, he may recover from his co-surety the latter's proportionate share of the balance. And if indemnity other than money has been provided by the principal for his sureties, but no satisfaction has been realized therefrom, this will not prevent the surety who has paid the debt from recovering contribution from his co-sureties. The principal debtor having mortgaged to one of his sureties as security against his suretyship land worth less than half of the debt, and then become insolvent, the unsecured surety gave to the mortgagee half the amount of the debt, and the mortgagee agreed to pay the debt, and to give to the other surety half of all that he might receive from the principal debtor. And it was held that this promise included whatever he might realize upon the mortgage previously given to him by the principal, but a mere indebtedness of the surety who seeks contribution to the principal is not available to the co-sureties, and where lands of the principal debtor are sold under an execution against him, and are purchased by one surety with money belonging to himself and a second co-surety, as this is not a fund coming from the principal, a third co-surety cannot maintain a claim to participate in the benefit of the purchase as indemnity against his liability with the other sureties. 143. A. Surety holding security regarded to a trustee thereof for his co-sureties. A security obtained by one co-surety for the payment of the debt is held by him for the benefit of all the sureties. He is a trustee for his co-sureties as to such security, and is subject to the duties which arise from that relation, and must refrain from any act or voluntary omission by which such security will be depreciated or lost, but must faithfully apply it to the payment of the debt, or he will be chargeable to his co-sureties with the amount of the security in the adjustment of their proportions of the debt. He must use reasonable diligence to secure the application of the property to the payment of the debt. All the co-sureties are liable among themselves for contribution to the extent of any balance that may remain due after such application. If one surety takes from the principal a mortgage or other security to indemnify him for becoming such surety, and afterwards discharges the same, it being of sufficient value to have paid the debt, he will by that act be prevented from calling on his co-sureties for contribution. But if the security discharged is of unascertained value, it has been said that the only remedy of the co-sureties is in equity. They will still be liable for contribution at law. Where one co-surety, having received security from the principal debtor, caused the same to be sold for enough to pay the debt, but never collected the money, it was held that he could not, upon afterwards paying the debt, recover any contribution thereto from his co-surety, nor if, having collected the money, he had then procured the original debt to be assigned to a third person for his benefit, would such assignee be allowed in equity to collect anything from the co-surety. 144. His rights and liabilities towards his co-sureties. The surety who holds securities from his principal will be protected from loss if he manages them with prudence, good faith, and integrity. A mere change of the security, made in good faith and not resulting in loss, will not discharge his co-sureties from liability for contribution. If his security is a chattel mortgage, he is not bound to take possession of the property until he has paid the debt, or has reason to apprehend that he will be called upon to pay it, and that the property will be squandered. Then, if he fails to take the proper steps to preserve the security, B may be charged by his co-sureties with the value of the property which by the exercise of due diligence he might have secured. If he has taken a mortgage as security, with an agreement that it shall not be recorded, he cannot be charged by his co-sureties for failing to have it recorded. He may, as against his co-sureties, be allowed for his necessary and reasonable expenses incurred in protecting the security, but not for any expenses unnecessarily incurred without the consent of the co-sureties. Where one of two sureties received from the principal debtor the latter's note for one half of the debt, payable on demand, by which he might secure himself whenever he pleased, and afterwards took another note from the principal for goods sold to him, and then recovered judgment upon both notes, and collected on the execution enough to pay the whole of the first note and part of the second. And then, the principal having become insolvent, the sureties paid each one half of the debt for which they were bound, The second surety being ignorant that the first had received any indemnity from the principal, it was held, on a bill in equity brought by the second surety against the first, that the first surety must account to the second for 1/2 of the amount of the indemnifying note that he had thus received from the principal. Where one surety promised the principal debtor, if the latter would consent to the sale of certain property mortgaged by him to the creditor for the payment of the debt, the creditor being unwilling to sell it without such consent, to buy it if it should be sold for less than its value, and hold it for the common indemnity of himself and his co-sureties, it was decided, on the purchase being made in accordance with the agreement, that a trust immediately arose in favor of the co-sureties, which could be enforced at their instance, that the surety so purchasing would be responsible for the property with its proceeds and profits, and for all losses that could be prevented by the care and diligence which trustees are bound to exercise, and should he allow the price which he paid for the property. 145. Surety may in equity prevent discharge of security held by his co-surety. One surety has no right to discharge to the prejudice of his co-surety a security taken for the indemnity of both. In a case in Massachusetts, it appeared that A sold goods to B, who mortgaged them to C to secure the latter against liability upon a promissory note signed by B, his principal, and by C and D as sureties. The mortgaged goods were levied upon in a suit against A as having been sold by him in fraud of his creditors. C then brought a suit against the attaching officer for a conversion of the goods, but afterwards agreed with the officer to discontinue the suit and discharge his mortgage, upon the officer's agreeing to pay part of the note and to collect the balance thereof from D, and it was held that D could maintain a bill in equity against the officer and C to restrain the discontinuance of the suit and the discharge of the mortgage, and for leave to prosecute the action in his own behalf. 146. Security held by one who let both a creditor and a surety. If one who is both a creditor and a surety takes security for the debt due to himself, as well as to indemnify himself from his liability upon his suretyship, he is entitled to appropriate so much of it as is necessary for the payment of his own claim in full, but he cannot hold it against his co-sureties on account of demands against the debtor which he has obtained after taking the security, unless it was agreed when he took the security that he should obtain the other demands and hold the security for them also. Though it is settled in equity that if one surety takes a security from the common principal for his own indemnity, this will inure to the benefit of all his co-sureties, yet if he has a security for individual claims of his own against the same principal, he may hold this for his own benefit. 147. Surety must contribute to cost of security of which he seeks the benefit. Waiver. One surety cannot claim the benefit of indemnity obtained by his co-surety from the principal without paying his proportion of the consideration therefor, and if an offer of indemnity is made to the sureties by the principal, on the condition that they shall give him a release, which offer is accepted by the one and refused by the other, though the latter could insist that the proceeds of the securities thus obtained by the former should be applied in reduction of the common debt, yet these securities could in no other way inure to his benefit, and this application would discharge the former surety from contribution to the latter, if it amounted to his proportion of the common debt. The complainants and the defendant being co-sureties for a debtor to whom the defendant was also indebted, the principal proposed to relieve the defendant from his liability as surety by giving a new note with other sureties, if the defendant would give him a sight draft for the amount of his indebtedness, or if he failed to procure the defendant's release from his suretyship, that he would then place the defendant's notes in the hands of a third person for the indemnity of the defendant alone. The complainant's assent to this arrangement was held to be a waiver of the right which they would otherwise have enjoyed to participate in the indemnity thus given to the defendant, but the facts that the complainants objected to the principal's making an assignment for the benefit of his sureties, because this would injure his credit, and agreed that he might procure the release of the defendant from his suretyship, if the latter would pay him the amount of his indebtedness, and that the defendant then said in their hearing that if the principal failed to carry out the arrangement for his relief, he should take measures to protect himself, are not sufficient to establish a waiver on the part of the complainants of their legal right to share in any indemnity or security which the defendant might afterwards obtain from the principal. 148. Right of one surety to stipulate, on becoming such, for a separate indemnity to himself. But if one surety on becoming such stipulates for and receives from his principal a separate indemnity, this is his exclusively, and his co-sureties can claim from him only the surplus of the proceeds thereof over what is necessary for his indemnification. So also, if the co-surety obtains indemnity from a third party, he has the right so to stipulate for a separate indemnity to himself, and to apply that indemnity upon his portion of the common liability to his own relief. And such an indemnity can be reached by his co-sureties only when it was taken in fraud of their rights or for their common benefit, and one surety is not entitled to the benefit of a mortgage which was given, and is conditioned merely to indemnify his co-surety after the co-sureties had adjusted their loss by each of them paying 1/2 of the sum for which they were bound. Though whatever payment one surety may receive from the principal must in general inure to the benefit of all, yet where payment of the debt for which all were liable has been made by one, and the claim against each for contribution has become fixed, each may on his separate account look to the principal for the reimbursement of his own share, and one of two sureties who has actually paid the whole debt for which both were liable may recover from the other surety half of the amount thereof, although since such payment he may have received from the principal the other half expressly for his separate indemnity. 149. A co-surety called upon for contribution becomes thereby entitled to subrogation. If one surety calls upon his co-surety for contribution, he must at the same time permit the latter to share in all the rights to which he has himself been subrogated by his payment. So one surety for the payment of a judgment, if he is held to contribute for the benefit of a co-surety who has paid the judgment, will thereupon be subrogated to the lien of the judgment upon the land of the judgment debtor. And if the surety who has paid the debt has discharged the principal from liability therefore, then, as this would prevent the subrogation of the co-sureties against the principal, they cannot be compelled to contribute for the relief of the surety who has made the payment. 150. Subsequent sureties not entitled to indemnity provided for prior sureties. Although the rights of co-sureties against each other are not affected by the fact that they became sureties at different times by different instruments, or even without each other's knowledge, if only they are as among themselves co-sureties, yet sureties who bind themselves after the liability of the original sureties has become fixed are not entitled to share in the benefit of an indemnity provided for the original sureties. Parties to a promissory note are prima facie liable successively in the order fixed by the note. Accordingly, the accommodation maker of a note cannot treat a mortgage given to the subsequent accommodation endorser thereof by the party for whose benefit the note was made, conditioned for the indemnity of the endorser, as a security taken by the endorser for the benefit of both of them, even though the endorser has since purchased the equity of redemption in the mortgaged property. The maker is liable to the endorser on the latter's taking up the note for the amount thereof, less only the actual value of the security. If, however, there are two successive accommodation endorsers of a note, and the second endorser, having been furnished by the maker with means to pay the note, promises the first endorser to apply these means for that purpose, and thereby lulls the first endorser into an action which would result in his injury if held to pay the note, this promise creates an equity in favor of the latter, which will support an action by him against the second endorser. The principal in a bond assigned a claim to a trustee for the indemnity of his sureties, in trust to collect the claim and apply its proceeds to the payment of the bond. Before the claim was collected, a suit was brought upon the bond, and the sureties contributed rateably to its payment. One of the sureties, having obtained a decree against the principal for what he had paid, took the principal in execution and obtained from him a bond with sureties, which was afterwards forfeited, and the new sureties paid the amount of the decree. The trustee having afterwards collected the claim assigned to him, it was held that the new sureties could not participate in this trust fund by subrogation to the rights of the original surety whom they had satisfied, that the surety who had obtained the new bond was bound to proceed thereon against the sureties therein, and could come upon the trust fund only for any deficiency in his recovery from them, and that the sureties in the new bond could not resort to the trust fund for their reimbursement, except to the extent of any surplus that might remain after the full indemnification of the original sureties. but the original sureties would not lose their rights by afterwards becoming sureties for the payment of a judgment recovered for the original debt. If they were then compelled to pay the judgment, they would be subrogated as if they had been held on their original obligation, so far as their interposition had not resulted injuriously to their co-sureties. 151. Extent of the right of subrogation among co-sureties. Creditor's interference with the right. The subrogation of a surety against his co-sureties is the equitable right of the surety himself, and is not affected by the relations existing between the principal debtor and the co-sureties against whom the right is sought to be exercised. It will be carried only to the extent of recovering from them their reasonable proportions of what he has paid, not exceeding, however, the amount of the obligation. For whenever two persons are compelled to contribute to a common burden, all the advantages acquired by one in dealing with the common creditor will be made to inure equally to the benefit of all. A surety who has paid the principal obligation by a conveyance of real estate can recover contribution from his co-surety only upon the basis of the real value of the land, though the price at which it was taken by the creditor may be evidence of this value. One of the sureties of an administrator who has bought up at a discount legacies, for the payment of which the sureties were bound, will be allowed to charge his co-surety only with his proportion of the expense actually incurred. Therefore, a surety cannot by means of an assignment of the creditor's remedies recover from his co-sureties more than their reasonable proportions of what he has himself paid. Nor will sureties upon one obligation have any equitable right to securities given by the same debtor to his sureties upon a different obligation. A surety will not, as against his co-sureties, be subrogated to any remedies for a debt which his co-sureties had the right to require him to discharge. The doctrine of contribution between co-sureties is not founded upon contract, but is the result of general equity. And any interference by the creditor with the surety's right of subrogation against each other will, to the extent of the injury received thereby, discharge the sureties who are so injured, just as a similar interference with their right of subrogation against their principal would have discharged them. The same right exists between co-sureties to be relieved to the extent of the share of each in the debt by the acts of the creditor, as exists between them and their principal to be relieved of the whole debt by similar acts of the creditor with their principal. And when the creditor by his acts discharges one surety or abandons a lien upon his property for the debt, he can hold the other surety only for a pro rata share of the debt. This doctrine is to be limited in the same manner, and with similar diversities of the decisions, as is the case with a similar doctrine of the release of the sureties by the creditor's interference with their rights against their principal. 152. One surety holding security from the principal holds it for the whole debt. As one of several sureties who holds security from the principal debtor to secure him against his suretyship holds it prima facie for the benefit of his co-sureties, as well as of himself, so he has a valid lien upon it, as against his principal, for the whole debt. Accordingly, where the principal maker of a note, which was also signed by three others as his sureties, made a mortgage of personal property to one of his sureties conditioned to indemnify him against his liability for the debt, the mortgagee was allowed, in an action against the mortgagor's assignee in insolvency, who had sold the property, to recover the proceeds of this property to the extent of his legal liability upon the note, although he had paid no part of the amount due thereon, and his co-sureties were equally liable with himself for the payment thereof, and although the consideration named in the mortgage was only 1/3 of the amount of the note. And parole evidence was held to be inadmissible, to show that the principal debtor had intended in giving the mortgage to secure the mortgagee only to the extent of 1/3 of what was due upon the note, under the belief that this would be a full indemnity for his liability. 153. Co-sureties' right of subrogation subject to legal rights of third parties. The equitable right of one surety upon his payment of the debt to be subrogated to the benefit of securities or property of the principal in the hands of a co-surety must yield to rights which have accrued to others upon the strength of the apparent legal title to such property. Accordingly, where an absolute deed of land was made to three persons, for the real purpose of securing them against their liability as sureties for a debt of the grantor, and they agreed to reconvey the land to him upon his payment of the debt, and then two of the sureties were compelled to pay the debt, the grantor and the other surety having become insolvent, it was held that the levy of an execution by a creditor of the insolvent surety upon the latter's undivided portion of the land vested in such creditor, the title to that portion unaffected by any equitable claims of the sureties who had paid the debt. 154. The creditor may be substituted to the benefit of security for the debt held by a surety. A creditor has also an equitable right to be substituted to the benefit of any collateral security for the debt which the principal debtor has given to his surety, and where property has been conveyed in trust for such a purpose, the creditor, although he was no party to the conveyance, may by a bill in equity have the property applied to the payment of his demand. The creditor will be entitled to the benefit of a mortgage assigned by the principal debtor to a trustee for the protection of his surety, with authority, on default in the payment of the debt, to collect the mortgage notes and pay the debt out of the proceeds. And a trustee who holds property which has been assigned to him by the principal debtor, with authority at the request of the surety on the latter's being threatened with loss by reason of his suretyship, to sell enough of the property to save the surety harmless, is not bound to wait until the surety hall have been actually compelled to pay the money, but should relieve the surety from responsibility whenever he has the funds in hand for that purpose. The creditor is in equity entitled to the benefit of collateral security for the payment of the debt taken by a surety from the principal debtor, although he did not originally rely upon such security or even know of its existence. The creditor and the surety have correlative rights. Each is entitled to the benefit of the securities held by the other for the payment of the debt. The creditor may, if necessary, compel the surety to surrender to him any peculiar means which have been entrusted by the principal debtor to the surety for the purpose of securing the payment of the debt, such as a mortgage on real or personal property or any other collateral security held by the surety. 155. Security held by a surety regarded as a trust for the payment of the debt. The security for the debt, in whosesoever hands it may be, is treated as a fund held in trust for the payment of the debt. If in the hands of the creditor, the surety, upon paying the debt, will be subrogated to it for his indemnity. If in the hands of a surety, the creditor may resort to it to secure the payment of his demand. Accordingly, such a security may by agreement of the parties be passed to a stranger upon his paying the original debt at the request of the debtor, and will be enforceable in the hands of such stranger. All demands received by the surety from the principal debtor for the purpose of discharging the debt, either by their transfer to the creditor or by the payment of their proceeds to the creditor, are held by the surety in trust for the creditor. Equity regarding the security as a trust fund created for the payment of the debt will compel the surety to apply it for that purpose, and voluntary transfer of such a security by the surety to the creditor will be upheld as if it had been made under a decree of the court. The effect of a mortgage or other security given by the principal debtor to his surety, conditioned that the principal will himself pay the debt and hold the surety harmless therefrom, is to create a trust and an equitable lien for the creditor, and the surety will hold the property subject to such trust, even though his own liability may have been defeated by his decease, or by the operation of the statute of limitations, or by the creditor's indulgence given to the principal debtor. The surety cannot defeat this trust by a conveyance of the property, except it be to a bona fide purchaser for value without notice, and the record of such a mortgage of real estate will be constructive notice of the trust, so that creditors of the surety or purchasers from him, even after his foreclosure of the mortgage, cannot, by means of an attachment or conveyance of the property, take it discharged of the trust. Nor will it be defeated by the subsequent insolvency or bankruptcy of the principal and the surety, or either of them. By such a mortgage the property is pledged to the surety for the payment of the mortgagor's debt, and the pledge is not redeemed, nor the equitable lien discharged, until the debt is actually paid. The surety cannot himself discharge the trust or relieve the property from the burden to the prejudice of the creditor. He may obtain security for the creditor, but he cannot discharge it. 156. Creditor's right to security held by a surety who is also a creditor of the principal. It has sometimes been held in Kentucky and in Mississippi that a mortgage given by a principal debtor to his sureties, both to protect them against the debt for which they are sureties and to secure a debt due to them from himself, will be applied to the payment of both debts pro rata. The rule has been laid down that since the sureties are quasi-trustees for the creditor in respect to such security, they are bound to pay over the first proceeds thereof to the common creditor, instead of applying them upon their own demand or paying them to their own general creditors. If the circumstances of the case are such as to show what was intended to be the priority of the respective parties, that intent will be carried out. Neither the creditor nor the surety can destroy the rights of the other in such a security. Each will be protected from injury by the acts of the other. The right of the surety to apply the security to the payment of his own demand before meeting that upon which he is liable as surety has also been maintained. The claim of the principal creditor to the benefit of such a security must be seasonably asserted. The principal debtor on a promissory note gave to the surety a mortgage conditioned that the principal should pay the note to the promisee thereof and hold the surety harmless therefrom, and should also pay a debt due from himself to the mortgagee. But the payee of the note did not make his loan under the inducement of the mortgage, nor was the mortgage made for his benefit or at his request. The principal paid the interest on the loan for several years, but no part of the principal sum or of his debt to the surety, and afterwards died intestate and insolvent, and his estate was never administered upon. The mortgagee was never called upon to pay, and never paid, either the interest or any part of the principal of the note, and his liability upon the note became barred by the statute of limitations. The mortgagee afterwards sold and conveyed his interest under the mortgage for a valuable consideration without notice to the purchaser that the payee of the note claimed any interest in the mortgage by way of trust or equitable lien or otherwise, and subsequent dispositions of the mortgaged premises were made without notice of any such claim. The payee of the note then brought a bill in equity against the mortgagee and the purchaser from him, praying that the mortgagee might be directed to turn over to him, as equitably entitled thereto, the proceeds of the sale to such purchaser, and that the purchaser might be decreed to hold the premises as a trustee for the plaintiff, subject to an equitable lien for the payment of his note, and to pay to the plaintiff the balance due from such purchaser to the mortgagee on his purchase, and it was held that he was not entitled to such relief. 157. Creditor's right to security held by surety measured by that of surety. It is generally considered that while the creditor may be substituted to the place of the surety in a case in which the creditor has given security to the surety, yet the creditor's right must be measured by that of the surety, and the surety's right to which the creditor will be substituted must be determined by the instrument which creates it. Accordingly, the creditor may usually hold security given by the principal debtor to the surety, but not bear indemnity given to the surety by a stranger, or by one co-surety to another. When the surety was accrued by a pledge of the rents of certain property, and afterwards became the holder of the legal title to the property, operating a merger of the pledge as between the principal and the surety, it was held that the creditor had no longer any right of substitution to the merged security. But if equity would prevent a merger, then the creditor's right would remain unaffected. If the condition of the surety's indemnity was that the principal should thus save the surety harmless by paying the debt in case he should be required by law to pay it, and it appears that the principal was not legally liable upon the debt, and that the surety has not been damnified, the creditor cannot have the benefit of the security. So, if the surety's rights were created by a trust deed which provided that, upon the recovery of judgment against the surety and the principal's failure to satisfy the same, the trustee should sell the property, the creditor could not subject the trust property to the payment of his claim without first obtaining judgment against the surety. If the liability of the surety is contingent, as is that of an accommodation indol 8 of a note, the creditor cannot be substituted to the benefit of a security held by the surety for his indemnity until this liability has become fixed. And if the endorser has been discharged by the lashes of the creditor, the latter's right of substitution is gone. If the surety holds the property only by a conveyance which is fraudulent as against the general creditors of the principal debtor, the creditor's right can be no better than that of the surety, and will not prevail against the principal's general creditors. 158. Security given merely to indemnify sureties cannot be enforced after sureties discharged. A security given to sureties merely to indemnify them against their suretyship cannot be enforced after the creditor has discharged the sureties. and where a debtor gave to high sureties such a mortgage to protect them against their suretyship, the mortgage was held to be extinguished by their assigning it to the creditor for high security, and taking from him a discharge of their liability. For as it was given merely to protect the sureties from their liability, and as that protection had been obtained by their discharge, the condition of the mortgage was fulfilled. So where the surety, having received from the principal a promissory note for high indemnity, handed this over to the creditor, and the creditor brought suit upon it against the principal, it was held that if the remedy against the surety upon the original debt was barred by the statute of limitations, there was a failure of the consideration of the note, and the creditor could not recover. But if the surety had given this note to the creditor in payment of his liability, then it would be no defense to the principal, when sued upon this substituted note, that the remedy upon the principal obligation had now become barred by the lapse of time. 159. When the surety's transfer of his indemnity to the creditor does not extinguish it. The transfer by a surety to the creditor of an indemnity received by the former from the principal will not always extinguish the security in equity, if the transfer is made in payment of the debt, or in consideration of the release of the surety by the creditor's judgment given by a principal debtor to his surety as n. Indemnity against his suretyship may be available before the surety is actually damnified, for the surety may use it to compel the payment of the debt by the principal, and upon the assignment of such a judgment by the surety to the creditor, the latter may, to the extent of his demand, collect it from the proceeds of the debtor's real estate upon which it was a lien. If the principal debtor gives to his surety a mortgage conditioned that the principal shall save his surety from any trouble or expense by reason of his suretyship, and the surety assigns this mortgage to the creditor in consideration of his release by the latter from any other liability than the use of his name in the collection of the original debt, this assignment will not extinguish the security, and the creditor can hold the mortgaged premises until they are redeemed by the payment of the debt. The surety has a right, for his protection, to apply the property to the payment of the debt, and the creditor may require this application. When an agent has undertaken to obtain security from a debtor of his principal, but has so negligently conducted himself therein as to become himself liable for the loss to his principal, and thereupon procures from the debtor a mortgage to himself for his protection against such liability, and subsequently, the debtor having become insolvent, assigns this mortgage to his principal, this assignment will not in equity extinguish the mortgage for the benefit of a subsequent mortgagee of the same premises, but the creditor will be allowed the full advantage thereof, to the extent of the agent's liability to him. 160. Surety's indemnity not available to the creditor unless insolvency intervenes. If the contract upon which a surety holds a mortgage or other security from the principal debtor is for the personal benefit of the surety in contradistinction to the idea of creating security for the debt or of providing means for its payment, the creditor can claim no greater rights or remedies in the security than the surety himself enjoys. If the surety himself has not been damnified and the conditions of his contract of indemnity have not been broken, as the surety himself could have no remedy, so the creditor, claiming under him and in his stead, can derive no benefit from the security. And until the creditor's interference, the surety may deal with it as he may choose. Security given by the maker of a note to his accommodation endorser to secure him against his liability on the endorsement, not being an accessory to the principal obligation, but simply a personal indemnity depending on the payment of the note by the endorser could not enforce the security until he should actually have been held to make payment on his endorsement. And the holder of the note, claiming through the endorser and merely standing in his place, can accordingly have no benefit of the security. A mortgage given, not to secure the debt, but simply to indemnify the surety, does not in the first instance attach itself to the debt, as an incident to it. But whatever equity arises in favor of the creditor in regard to the security comes into existence only upon the insolvency of the parties holden for the debt, and until this equity arises the surety has a right in equity, as well as at law, to release such security. 161. Application of the principles Law Connecticut. A debtor mortgaged certain real estate to B, to secure the latter for accepting his bills to a large amount, the condition of the mortgage being that the debtor should pay all such acceptances at their maturity, and save B, harmless therefrom. Afterwards, the debtor desiring to obtain a loan from a bank, an arrangement was made by which b. mortgaged to the bank all his interest in the premises as security for such loan, and the bank made a loan to the debtor upon this security. Both the debtor and b. were at this time solvent and in good credit, but they both soon afterwards became insolvent, the bank's loan being unpaid, and b.'s acceptances being still outstanding in the hands of parties to whom they had been negotiated. The holders of these acceptances then claimed that the mortgaged premises should be applied to their payment, but it was held that this mortgage was to be regarded as a personal security created for the indemnity of b. and not to secure the payment of the bills. That while the parties were solvent, the holders of the bills had no equitable right to the security, and in the meantime, until such equitable right arose upon the insolvency of the debtors b. had a perfect right to surrender his security, or with the concurrence of the debtor to transfer it to the bank as a security for a new loan, and that the rights of the bank to the security were not affected by the equity which afterwards, upon the failure of the debtor and of b. arose in favor of the holders of the bills. 162. The creditor is entitled to the benefit of the surety's indemnity when insolvency intervenes. But the creditor will be entitled, upon the insolvency of the principal and the surety, to the benefit of security held by the surety from the principal merely for indemnity, if the creditor has not waived this right by proving his demand as an unsecured one against the estates of those who are liable to him thereon. Where an assignment of property was made to secure an endorser against the payment of certain notes endorsed by him, and he sold the property and converted it into money, and then became insolvent, the notes being unpaid, and the maker being also insolvent, it was held that this money, having been kept separate from his other property, did not pass to his assignees in bankruptcy, but that equity would follow the fund and apply it to the payment of the notes. Where the purchaser of land procured a third person to give his note to the vendor for the price thereof, and to secure the maker of the note gave him a bond and mortgage on the land purchased, and the maker of the note became insolvent before it fell due, the vendor of the land was held to be entitled to the benefit of the bond and mortgage. The same rule has been applied upon the insolvency of the principal and the DTH of the surety who held the indemnity, and also upon the bare insolvency of the principal. But to give this right of substitution to the creditor, the relation of debtor and creditor must still subsist, both between the creditor and the surety, and also between the creditor and the principal. And if the surety has lost his lien, the creditor's equitable right of substitution thereto is also destroyed. 163. Surety's indemnity, sometimes treated as a trust for the payment of the debt. The broad doctrine has also been often asserted that equity will regard security given by a principal debtor to high surety, though merely for the surety's indemnity, as a trust created for the payment of the debt, and will see that it is applied for that purpose, by substituting, if necessary, the creditor to its benefit. So it has been held that in Chancery, on the creditor's application, a fund pledged by the principal for the indemnity of the surety will be applied directly to the payment of the debt, if the surety is liable for its immediate payment, and could upon his payment resort at once to this fund for his indemnity. On this principle, an accommodation endorser for a firm, who has been held to payment upon his endorsement, has been subrogated for his protection to the benefit of bonds given by each partner to the other upon the dissolution of the firm, to protect each respectively from the debts that were assumed by the other. Where the creditor recovered judgment against both the principal and the surety, and the other property of the principal being insufficient to satisfy the judgment, the surety directed the sheriff to levy the execution upon property mortgaged by the principal to him for his indemnity, which was accordingly done. It was held that the sale of this property upon the execution was valid and absolute, and that it extinguished the lien of the surety's indemnifying mortgage. 164. Partial surety not to be harmed by the substitution of the creditor to his indemnity. But a surety who is not liable for the whole debt is not to be harmed by the creditor's appropriation of his indemnity. It must be applied first as may be needed for his protection. The mortgagee of a tract of land which is subsequently sold to a third party may elect to be substituted to the rights of such third party in a mortgage upon other property which the latter has taken to indemnify himself against the lien of the first mortgage. but in doing so he vacates the lien of his own mortgage upon the land which has been sold to the third party. Where a surety executed a mortgage upon his own land to secure the payment of his principal's notes, with a provision that the surety should not be subjected to any further loss or liability than that which was created by this mortgage, and the surety afterwards took security from his principal to indemnify himself against any loss that he might sustain by reason of this mortgage, it was held that the surety's liability was limited to his own property mortgaged, together with any surplus remaining in his hands out of the security received by him from the principal after fully indemnifying himself therefrom for any loss resulting to him from his mortgage of his own property, and that the holders of the notes could either enforce the mortgage or abandon the mortgage and resort to the security received by the surety from the principal debtor, or hold the mortgaged lands and any surplus of the security that might remain after fully indemnifying the surety for his loss by their resort to his lands, but that they had no further rights against the surety, either directly or by substitution to his security. A creditor of a firm consisting originally of two partners, one of whom is deceased, will be compelled to proceed against property in the hands of the surviving partner before resorting to property which has been deposited by the deceased partner with his surety to indemnify the latter against his suretyship upon both this and other obligations. Where a surety upon several promissory notes takes a mortgage from the principal, conditioned that the principal shall pay the notes and so save the surety harmless therefrom, and so holds the mortgage in trust for the holders of the notes, and he remains personally liable on only one of the notes, and the principal debtor is insolvent, the mortgaged property, if sufficient to pay all the notes, will be applied for that purpose, and any surplus will be distributed among the general creditors of the mortgagor. But if the mortgaged property is insufficient to pay all the notes, it will be first applied for the indemnification of the surety, by paying in full, if necessary, the note on which he remains liable, and the surplus will be applied to the payment of the other notes pro rata. 165. Creditor cannot be substituted to a security not created against his debt. Although a creditor of a mortgagee may, by substitution in equity, avail himself of the rights of the mortgagee under a mortgage made to secure the debt which he is seeking to recover, and which is due to himself, yet he cannot do so unless the mortgage was made to secure that very debt, and the fact that a mortgagee has joined with his mortgagor as the latter's surety in a bond given by him to a second mortgagee of the same premises, gives the second mortgagee no equitable interest in the lien of the prior mortgage. Nor in such a case would the insolvency of both the mortgagor and the prior mortgagee entitle the junior mortgagee, in the absence of any fraud practiced upon him, to be substituted to the rights of the prior mortgagee. Nor can the plaintiff in an action for the recovery of a debt hold money which has been deposited by a third person with a deputy sheriff as security to the deputy that persons whom he has accepted as bail of the defendant will justify as such bail. 166. Cases in which a creditor has sought to be substituted to securities held by a surety or by one under a secondary. The principal debtor and two sureties having joined in an obligation to the creditor, the principal gave to one of the sureties a mortgage to secure its payment and save the sureties from loss. Afterwards the mortgagor and the mortgagee joined to convey an interest in the mortgaged property to a stranger, who retained in his hands a portion of the purchase money to meet the charges thereon. The holder of the original obligation then claimed that he was entitled to be paid out of the mortgaged property by substitution to the benefit of the mortgage, and it was held that he had a right to be so paid, and that this equitable right of his was not affected by the mortgagee's having joined in the conveyance to the stranger, especially as the latter had not only had notice of the mortgage, and consequently of the rights of the creditor thereto, but also had actually retained in his hands a portion of the purchase money for his protection therefrom mortgage, which recited that the mortgagee had endorsed certain notes for the accommodation of the mortgagor, upon the condition that the mortgage should be given to secure him from any loss that he might sustain in consequence of the maker's non-payment of the notes at their maturity, was conditioned to be void if the mortgagor should pay the notes or should repay the mortgagee upon the latter's paying them, and provided that the proceeds of any sale of the mortgaged premises should be applied to the payment of all claims of the mortgagee under the mortgage, whether then or thereafter payable, was held to constitute not merely an indemnity to the endorser, but a security for the payment of the notes, so that any bona fide holder of the notes might maintain a bill to foreclose it, and his rights would not be affected by a release given by the mortgagee. But it has been decided in New Jersey that a mortgage given by a guardian to the sureties upon his guardianship bond, conditioned to be void if the guardian should comply with the condition of the bond by paying over all the money in his buds to his ward upon the latter's arrival at full age, creates no trust for the benefit of the minor, but the mortgagees are the absolute owners of both the legal and the beneficial interest in the mortgage, and have the full right to treat it as their own. The contrary has also been held. 167. Creditor substituted to the claim of his debtor for reimbursement upon the party ultimately liable. A creditor may also be substituted to his debtor's claim for reimbursement upon one who is under no liability for the debt, where the latter is the party upon whom the burden of the debt ought ultimately to fall. Thus, where an insurance policy had been properly assigned by the insured as security for a loan of money made to him by the assignee, but after a loss had occurred, the insured having failed and the insurance company having another claim upon a bottomry bond against the insured and a surety upon this bond. The company, being indemnified by the surety, retained the amount of this claim out of the loss upon the assigned policy. Instead of collecting it from the surety, the assignee of the policy was allowed in equity to be substituted to the claim of the company upon the surety, to the extent of the amount so retained by the company out of what was due to him upon the policy. So also the placing of notes in the hands of an attorney as collateral security to collect them, and to apply the proceeds upon a judgment against the person depositing them, creates an equity in favor of the judgment creditor, which will be enforced upon his application, although the attorney's receipt for the notes has been transferred to a third person. Where a mortgagor, having paid the amount due upon the mortgage to the mortgagee after the latter had, without the knowledge of the mortgagor assigned his mortgage, took from the mortgagee, after learning the facts, a bond conditioned that the mortgagee should pay to the assignee of the mortgage the amount that was due thereon and save the mortgagor harmless therefrom, it was held that the assignee of the mortgage was entitled to the benefit of this bond, and could enforce it against one who had guaranteed it to the mortgagor, although the latter had given an acknowledgment of satisfaction thereof to the mortgagee, the court saying that the mortgagor could obtain from the mortgagee who had become the person ultimately liable in equity to pay the debt security for the holder of the mortgage, but could not, as against the creditor, destroy that security when obtained. 167a. Bondholder substituted to benefit of security given by party ultimately liable. Where, to aid in the construction of a railroad, a state issued its bonds in exchange for those of the railroad company, under a statute which created a mortgage for the protection of the state, the holders of the state bonds were held to be entitled to the benefit of this mortgage, after the state bonds had been decided to be invalid as having been issued without constitutional authority. So in the case of bonds issued by a county to a railroad company, for which that company gave a mortgage to the county, the bonds having been sold in the market and the coupons remaining unpaid, it was held that in equity the railroad company must be regarded as the principal debtor and the county as the surety, and that the bondholder were entitled to be substituted for the payment of their coupons to the benefit of the mortgage. The security to the state or county was considered to be, not only for its own protection, but for the better securing of the bonds. But where a corporation has conveyed lands to a state as a bare indemnity to the state against loss on the state's bonds issued to the corporation, the bondholders cannot, as against the state, compel the land to be applied to the payment of the bond, and the grantees of the state will take the land free from any claim of the bondholders. The question apart from any considerations of sovereignty has been taken to be whether the railroad company or the state should be regarded as the principal debtor, and whether the statutory lien was intended to be available for the benefit of the bondholders. But where a town made a lawful appropriation to a railroad company and issued its bonds therefore to the company, the purchaser of these bonds from the company could not claim to have paid the appropriation by his purchase, and the bonds being in default, and having been held to be void in his suit against the town, was not subrogated to any right of the railroad company to enforce payment of the appropriation by the town. He was not a creditor either of the company or of the town. He had paid no debt of either, and had no right of subrogation against either as his debtor. 168. Substitution to the securities held by the sureties in a criminal recognizance. The substitution of the creditor to the securities held by the sureties does not extend to the case of a recognizance taken in the course of criminal proceedings before the liability of the sureties has been fixed at law. Thus, where the principal in such a recognizance gave a trust deed to his sureties therein, providing that if the recognizance should be forfeited and the sureties become liable thereon, the trust property should be applied to pay the recognizance so far as it would go. It was held that the state could not maintain a bill in equity to subject this property to the payment of the amount due upon the recognizance before obtaining judgment against the sureties. The doctrine of subrogation does not apply in favor of sureties or bail to bonds taken in the course of criminal proceedings.